morning, everybody, again. So we're back. So while I was going to get my cough syrup and everything, I did get a message, something I checked out as soon as I got home, and I have got most of the information here. So what I'm going to do is let a few more people get in here before I start with this so I don't have to repeat it. Good morning, good morning, good morning, everybody. Yes, please smash that like button on your way in. It is free. Good morning from England, New Zealand, Idaho. All over this morning. Good morning, K-Mitch. Good morning, Judy, Brenda, Bonnie, BNN, Lion, Cassie, Diana, Rosie, Sherry, Lisa. Good morning, everybody. Kapal, good morning, West Virginia. Bracebridge, Ontario. Fellow Canadian, hello. Sarasota, Florida, North Carolina, Ohio, Florida. Woohoo. Welcome, everybody. Norway. Welcome, Norway. Good morning, everybody. I'm feeling a bit better, but it's now going into my chest, so that's why I had to run out this morning and go and get some of the Mucinex. And I did take somebody's advice. My sister sent me a message to not get the extended one, so I got the regular one. Morning, Willow, Mitchell, Ontario, Canada in the house. Hello, all my fellow Canadians and all my friends in the U.S. and around the world. Hello, Hawaii. Hello, Annie. I'd love to go to Hawaii. Utah. Okay, you guys, so let's get going on this. Hello, everybody coming in. So there's some updates with the Barry Morphew case. So we all know that he was released on September 20th on bail conditions. One of those bail conditions was that he had to reside in Chaffee County, right? So the very next day, on September 21st, he was also ordered to wear an ankle monitor, and he was not allowed to leave Chaffee County. So he had to have this GPS monitor on. Well, the very next day at 9:23 a.m. in the morning, the company that monitors him at his residence where he's chosen to stay, they cannot pick up a signal. So they have no idea whether he's there, if he's tampering with his GPS tracker, which is the ankle monitor. They can't tell if he's even at that residence because there's no signal. Okay. So that was the very next day after he was released. The district attorney filed some motions to get this back into court to change the bail conditions. Now, there's a few different things that have come up. That was the first motion that was filed, that they want this hearing because he can't be traced. So there's no sense of him even having this GPS monitor on, because the company that's monitoring it is saying, like, if he breaks it off and takes off, we have no way of knowing that, because they have they get no signal from the monitor where he is living. He's in Maysville. Okay, we're going to get to that. So they have no idea whether he's even there. He could be in Timbuktu by now. We don't know. Because if he would have broken that ankle monitor off and took off, hightailed it, they've got no way of tracking him. So that was the very next morning after he was released that the company called the DA and said, look, we can't track him because we don't get a signal out there in Maysville at the house where he's staying, at the location. So there's no alerts, nothing being sent to them. So right away, The next morning after he was released, the DA filed a motions hearing. They need to do something about these bail conditions and about this ankle monitor. Now, that was at 9:23 a.m. in the morning on September 21st, so the day after he was released. An hour later, they filed another motion. Okay, Linda Stanley filed another motion to modify the bail conditions so he cannot reside in Maysville. Okay, and there's several different reasons. One of the reasons is they cannot, the GPS monitor will not work out there. And he's living at the Cushmans. Okay, the Cushmans, as you guys know, is all buddy with Barry, right? And could, okay, I'm not even going to say it. I was going to say something, but I'm not, because I don't want to start a rumor or anything. It's just my personal feelings that there could be more with the Cushmans. But the Cushman residence is only a couple hundred yards from Barry and Suzanne's Puma Path home. Okay, it's an Airbnb. It's in the Monarch Estates. Okay, and it's at 19087 Puma Path Drive. Okay, so that's not very far from, it's only hundreds of yards from Barry and Suzanne's Puma Path home. Okay. Also, there is a witness protection order on the Ritters. Okay. The Ritters is also very close to where Barry is staying, hundreds of yards from the home. And he's been ordered, they want to prohibit him from being anywhere near the Puma Path home that him and Suzanne had shared, which would get him out of the Cushman's residence, okay, where there is no service for this GPS monitoring. Also, the Ritters have also contacted the DA saying that they're uncomfortable. They don't even want to reside in their own home because they're under a witness protection order. And they want no contact with Barry whatsoever. And they are, because he is so close to them out in the middle of nowhere, they are scared. Okay. So they're going to be asking for a prohibition order. Okay. And they've also come across that he is paying for rent in Salida at 315 Poncha Boulevard. Okay. And that's where they want him to reside. He's already paying rent there. It's right by the courthouse. And that's where they want him to reside so they can monitor him properly with this GPS, because the GPS cannot be monitored out in Maysville. So being that he's already paying rent there, that's where they want him to reside. And guess who lives there? Shoshana. Okay. Now, this all came into play, you guys, before Shoshana got arrested. So we know that Shoshana's been out at Barry's in Maysville. So it's not a secret that they are still some kind of a way connected, because Barry's still paying the rent for the 315 Poncha Boulevard in Salida. That's where Shoshana lives. Shoshana went out there and, as we know, went to Barry Morphew's old residence and stole or took a parcel from the porch there, which she has been charged for. I think she's in court October 7th for that. And the courts are asking, it's not the people that own the Barry and Suzanne's old home that are asking for this, but it's law enforcement that is asking for a restraining order against her being anywhere near that home. So, which would mean she wouldn't be able to go to see Barry a couple hundred yards away either at the Cushmans. But the Ritters are also saying that they are afraid and they are uncomfortable. They don't even want to reside in their own home because Barry is so close to them and it's out in the middle of nowhere, right? And they're in the witness protection. They're covered under that witness protection order. So yeah, he never should have been released. So his court date isn't until October 13th. You would think that this would be immediate, but no. This was known the very next day once he was released that he could not be tracked because they have no signal out in Maysville at the Cushmans where he's supposed to reside. So he could be taking that ankle monitor off and going and doing whatever he wants to do, and they're not going to even know about it. Aloha, Shelley. And he doesn't even have a court date to modify any of this until October 13th, almost a month later. So since September 21st, the day after he was released, they became aware that he could not be tracked. And they have not set a date for to modify these bail conditions until October 13th, which is next week. So from September 21st until next week, which he has to appear in court, that's part of his bond conditions, that he has to appear at every court date, he could be gone, and we don't even know about it. He could be gone. Just saying. K. Mitch, the Cushmans are very good friends of Barry's, and I'm going to leave it at that. And they have been very big supporters of Barry. So that's what I wanted to get on here a little bit earlier and bring up, and give you guys some time to maybe chit-chat about it. Chit-chat about a little bit about the Brian laundry, what's going on there. Let me just jump over here and see if I have any updates on that. Just give me a second, you guys. Yeah, also yesterday I had a problem with my live. I couldn't see any more of your guys' chats or anything. Oh, sorry, sis. I've been just running around like a chicken with my head cut off. Didn't even think about it. I'm sorry. Now I forget where I was at, what I was going to say. Oh, my brain's still foggy. What was I going to say? Oh, yeah. Yesterday during my live, I couldn't see your guys' chat. Apparently you guys could still hear me, but I couldn't see nothing on my StreamYards on chat anymore. Now, I don't know if somehow they're connected with the Facebook thing that's been going on. But I couldn't get into my Facebook. I couldn't get into my Messenger. I was finally able to get into my messaging this morning, but my Facebook still isn't working properly. Things still aren't loading. But my Messenger is now working, and I don't have TikTok and all that, so I don't know if any of that is still down. But I think that there was something with the StreamYards too yesterday, because I couldn't see any of you guys chatting or anything. So that's why I just ended that live. So hopefully we don't have that problem today. Okay, let me just check you guys. Yeah, I just don't know why they are waiting so long to get this back in front of the judge. Like, they don't know where he is. They can't track him. So he could be at the Cushmans where he's staying and taking that ankle monitor off and going and doing whatever. And they would have no clue, because they would not get the alerts for that, because there's the GPS needs internet connection. Yes, Shoshana is in court October 7th. And there's going to be a restraining order that she's not allowed anywhere near the Puma Path home. Okay, so Barry Morphew, his ankle monitor is not working. They haven't been able to track him since the day after he was released, because there's no internet out there to get the connection for the GPS that they need. So he could be taking off his ankle monitor at the Cushmans where he's been saying he's staying, and going and doing whatever. He could be in Mexico right now for all we know, because they can't get a signal for their GPS to track it. It also is not going to give them alerts if he's taken that bracelet off. So, okay, let me just go and check you guys and see if I can find anything else about Brian laundry while we're waiting for the Chad Daybell thing to start. Yeah, I guess there was problems with Twitter's having problems too. Just checking here, you guys. Sorry, you guys, I had to have a bad cough there, so I muted. Just give me a second. Yes, I am feeling a bit better today, you guys. It is moving. Okay, where was that? Faye Dawn says, you sound a lot better today. Yes. My sinuses, one side I can now breathe through, the other side's still blocked. My throat's not sore no more, nothing like that, but now it's moving down into my chest. So that's why I'm going to be muting myself a lot. So guys do not have to hear me cough. And I'm guaranteeing you guys, if you got a chest cold or congestion in your chest, get this Mucinex. It works awesome. It's already starting to work. So that's too much information. You guys don't need to know. But I will mute myself for that. Yes, please smash that like button, you guys. We will be bringing you live the Chad Daybell motion hearings that are happening this morning. It's going to be to change a venue. There's going to be a ruling on that. And he also wants to sever his case from Lori's. Now, I know, whoops, what did I do? Oh, I know the prosecution has been fighting that because they're saying that Lori's not here to defend the separation and this and that, whatever. But I mean, and you guys know me, I'm no fan of the Daybells. I call them the Dunbells, the circus. But I think he has a right to separate himself from her if he so chooses for his defense. Either way, I believe that they're both going to be found guilty anyway. But let's stop. Like, we had a trial date set and ready and raring to go. And as we all know, that has now been squashed. And now the trial date looks like it's not going to even start until next year. So yes, please be creative in chat. Thank you. I'm just trying to catch up on some of the chat here, you guys, while we're waiting. Don't say that, Christina. Christina says Barry is probably following the Brian Laundrie case and taking pointers. He'll be the next America's Most Wanted. This is ridiculous. It is. A cup of color says, girl, you have every sign of COVID. No, I've been tested. It's not COVID. I've had problems with my sinuses since I was a child, and I also have asthma. So a common cold for me turns into something major because of those problems I've had since asthma I've had, I think, as far back as I can remember. So I think since I was born, maybe shortly thereafterwards. Then I started with sinus problems at a very young age too. So with those combinations, a common cold turns very bad for me very quickly. So yes, they did test me for COVID, and I do not have COVID. But thank you for your concern. Okay, let me get back to... Okay, let me just go and check over here, you guys, to see what's going on. Is Hobby Cat. Thank you so much for that donation that you sent to. Thank you. Judy says, I think Brian is developing full-blown schizophrenia on top of his narcissism. I don't think he's got schizophrenia at all. He knows exactly what he's doing. Yep. I know. Christina, it was so hard. It was like, it's in my blood, right? Especially stuff like this and cases that I get that close to. It's kind of hard to just turn away from it. You can't. I hope you guys can't hear me slurping my coffee, but it helps break up all the congestion. Yeah, so Barry Morphew, I wonder if he's going to show up for court on the 13th. So October 13th, I don't know. I'm sure that I'll be able to find out what's going on in that courtroom. So I'm going to have to, give me a second, you guys. I got to get this all marked down or I'm going to forget. You know, my memory. It's crapola. I'll have to get the time for it, you guys, and then I will make a thumbnail for it and put it up before the date so you guys can set a reminder for it. I'm not sure of the time yet. I gotta go back and look at the court papers. But I do know it's on next Wednesday. And October 7th, Shoshana is in court for a restraining order. And that's the DA going for the restraining order. Okay, so let me just... Everybody get their coffee, so I'm not alone. I got to put it in my phone, too, because... And set a reminder, or like a squirrel. Okay, very Morphew. I saved that. Okay, saved everywhere. If I miss that, you guys, I'm giving up YouTube because I've got it saved 3 different places. My memory is bad enough, and then on top of being sick, it's like... Sherry Ledger said, what did she do? Are you talking about Shoshana, Sherry? Hey, Cindy. Hi, Rosie. Hello, everybody coming in. We're going to be getting going on this probably about 5 minutes, you guys. We're going to see what the judge is going to decide with Chad Daybell, Lori Vallow, see if the cases are going to be severed and to see if they're going to change venue. I've also heard, you guys, a little chit chat going on. I don't know how true it is, because I haven't been able to verify it. So I hope we get verification of that as we watch this hearing this morning. But I've heard little bees humming and chit-chatting it up, saying that if they change venue, what they want to do is wherever the defense wants it changed to, they want to just get a jury from that area and bring them back to Fremont and have them. So in other words, it's just going to be, they're going to get jurors from outside of the jurisdiction and bring them into Fremont and sequester them. That's what I'm hearing. This is pretty bad, you guys. I had my neighbor go and go to Walmart while I was at the pharmacy and grab me a 8-pack of Kleenex. And they're rough. I gave her $20. Get the best ones. My nose, my poor nose. Because I am out of my puffs. But what did she get me? Royal. And they're not really that soft. But I need them because I am going through tissues like you wouldn't believe. So yeah, so that's what I'm hearing, is that they want to get a jury pool from outside of Fremont County and bring those jurors in and sequester them in Fremont County. So they don't have to have everybody daily, because this trial is probably going to go on for like a month and a half. They don't want the DA and the lawyers and everybody that's in Fremont to have to travel daily back and forth to wherever. So this is the buzz that I've been hearing. It hasn't been confirmed yet, you guys, but I'm hearing the buzz that they just want to go outside of the jurisdiction to get a jury pool to bring into Fremont County and sequester them, which is usually they don't get sequestered until they go into deliberations, but they want to sequester them for the whole month and a half. Like, can you imagine being a jury, being sequestered from your family for that long? It's like, ooh, I don't know. Okay, so I am going on watch now, you guys, for this hearing. Oh my gosh, what did I just do? Oh, I'm an idiot. Sorry, I should have muted myself there, you guys. Sorry, but I was looking over here. I could just see it, my whole front veranda covered with puffs. Yeah, I don't know, Cindy. Like I said, it's just something that I have heard being buzzed around. It's not verified yet, but I think that that's what they are going to want to do if the judge decides that this needs to be moved and grants the change of venue. I think that they're just going to go outside of the jurisdiction to get their jury pool and then bring them into Fremont and sequester them. That's what the buzz that I've been hearing. So if that's true or not, I don't know, but I don't see how that would make any juror happy. And I mean, I don't know if they're going to get, like, I'm in Canada and I know about this trial. I know what they did. Like, where are they going to go? Like some little country that population, how many jurors do they need? 12? With no internet, no nothing? Like, I don't know. I don't know. So as soon as this starts, you guys, I will click over to it for you guys to see. I'll put it up so you guys can follow along. I ask once I get it up, please hit 1 in the chat if you hear it once I get it up. Because I don't know what I'm doing wrong lately, but sometimes you guys can't hear it. And I am sharing my audio and everything, so it's set to start any minute, you guys. Well, it's 11 a.m. now, so it's supposed to start now. But we know from previous experience, they never start on time. Let me just check here. I hope that they are streaming it, you guys. I don't see why they wouldn't. Yes, it's to decide the change of venue and to make a decision on whether they're going to sever. Okay, I'm going to mute myself for a minute, you guys. I want to just go and check something else. Hang on. Okay, yeah, it's saying that it's supposed to be live streamed here, so I am watching it, you guys. Oh, Tuesdays are large motion hearing days? Okay. So that could be why. But I am keeping my eye here. And as soon as it starts, I will go full screen with it so you guys can see everything. Let me just check something else here, you guys. Oh my God, I'm an idiot. I'm here chatting away to you guys and my mic was muted because I had to cough again and I muted it and forgot to put it back on. So if I forget to put it back on, you guys got to give me a break. Today's not a good day. I am checking the court thing too, you guys. Checking a couple different places actually where I guess we're just going to have to wait. They are never on time, you guys, so please bear with me. I'm just checking a few. I can't see chat right now, so... My sister just told me that Kleenexes are coming in Thursday night. Yay! It still hasn't started yet, you guys. I'm checking. I got my sister checking too, so... Crap. What did I do again? Oh my God. What did I do here? Sorry, you guys. I've got another screen up and I'm trying to... I don't even know if I'm muted. I can't see my StreamYard, so I don't even know if I'm muted. But if I am not, I'm just checking some different places here. WebEx and Zoom and stuff. So far, there is nothing there. Okay, let me go back. Oops, there's my sister. Maybe she found something. Okay, she's been checking too. Okay, let me check over here. Okay. It hasn't started yet. Um, Okay, it is showing that they are live. Wait a minute here. Okay, I got it, you guys, I think. Yeah, I got it. I got it. I got it. I got it. Okay, give me a second, you guys. I'm going to get this up and then I will share it.
Vermont County, and also is being reported by the court reporter. In addition, in order to allow public access and help and allow for that access, the hearing's being live streamed on the court's YouTube channel.
Okay, so can everybody hear it?
So we've got motions. This was originally scheduled on a change of venue motion. In the interim, we've had other motions filed of late.
Okay, you guys can hear it?
I think
Great.
need to be brought up first.
I'm going to mute myself now.
The motions that I see are pending today. There was the change of venue motion that was filed by the defendant on July 21st. The state filed its response to that on September 29th. On September 29th, also the state filed a motion to sequester a jury and bring a jury in from another county for the case. On October 4th, Mr. Pryor filed a response to that motion and also a motion to continue the hearing on that motion. And I allowed for shortened time to hear the motion to continue. Also, there was a motion to seal the hearing today that was, I think, filed yesterday on October 4th. And that was under a request by the state to seal today's hearing. And so I think the first issue we need to bring up probably is the motion to seal the hearing, which was filed on September 30th. And I've reviewed the motion. I'll hear argument on the motion at this time. Ms. Blake, if you're the one that's going to be arguing that motion to seal.
Your Honor, I'll be arguing that motion.
All right, thank you, Mr. Wood.
We'd ask that this motion be heard, not in the public view, where we're discussing issues that might need to be sealed. We leave that to the discretion of the court, but we don't think this specific portion of the motion or hearing needs to be broadcasted.
All right, any response, Mr. Daybell? I'm sorry, Mr. Pryor. Yeah.
Mr. Daybell is judge for the record to my right today in the office. Judge, frankly, there's no reason to seal this hearing. I previously provided to the court, I believe just short of 8 o'clock this morning, not only a list which had previously been described of all my exhibits, but also the thumb drive containing all the exhibits, as well as the slides that I anticipate using as part of my venue. From my perspective, there's nothing objectionable, and I purposely, obviously had a discussion with the
Your
court.
Honor, he's arguing not about whether or not we should, about the actual motion, not about whether or not this portion of the hearing should be not be live streamed.
Well, Judge, the point is that there's no reason to seal this. This idea that everything should be sealed because the prosecutor doesn't want it disseminated out in the public. The right to a fair trial and the right to everybody hearing the evidence and what's being alleged by both sides is particularly important. And I can't for the life of me understand why this prosecutor wants to stop the public from observing the reasons for this court to potentially change venue. Now, I understand.
Again, Your Honor, he's already arguing the motion. I haven't even had a chance to.
I'm not arguing the
Totally
motion.
inappropriate.
And
Well,
it's
I
not
understand.
inappropriate.
Counsel,
It's not inappropriate.
it's a fairly straightforward issue. And let me just indicate, part of the issue here is typically if we didn't have the COVID issues and the limited court operations as a result of that, we would be doing a hearing in person. And if we were doing a hearing in person, then we would be in open court. And then the question would be, are we going to be in open court or closed court? Because of the COVID restrictions we've got and an order we just had recently, which imposed further restrictions, the court determined that conducting this remote was in best interest of complying with that Supreme Court order for this type of motion and hearing. On the Idaho Court Administrative Rule 32 does give the court some discretion to seal or close certain hearings, or either close the hearings, seal the record of the proceedings, or both. The court has considered that in the context of this motion. And I do find that this is a hearing that typically would be open to the public. It does deal with some issues that could create further dissemination of the information we're talking about on the change of venue. But I think there are ways to do that that are less restrictive than simply closing the hearing and sealing the proceedings. That's kind of a remedy of last resort under Rule 32. And so I am going to deny the motion to seal this hearing. Part of the issue also is, well, what I'm going to do is, I do know there are potential exhibits and there may be some testimony that needs to go off the record. And that can be done in the context of, I'll give you an admonishing instruction that if we are going to get into information that's clearly inflammatory, that's clearly going to possibly create an unfair bias or prejudice to potential jurors in this case, then I'm going to admonish counsel not to just put those matters out there without giving me an opportunity or the other side an opportunity to object and determine whether or not that should go into a closed portion of the hearing where we can go still on the record, but outside of the live stream portion of the proceedings. The exhibits can be reviewed in camera. I'm going to instruct counsel, they're not going to be broadcast or live streamed, the particular exhibits that may be used in support or opposition to the motion. And so with those precautions in place, I don't think we rise to the level of needing to close the hearing and seal the proceedings under 32, because again, this is typically something that the public's entitled to see as an open hearing in a criminal proceeding. So with those admonishments in mind, counsel, we're going to go forward. This will be an open hearing. And if we do have matters that need to be taken up off the record, we can do that. And I have the ability to close that part of the hearing or seal that part of the proceedings. So that'll be my ruling on the motion to seal. Any questions on that ruling, Mr. Wood?
No, I would just note on the record that the state filed a motion. Mr. Pryor clearly argued that the state was not allowed to make any argument in favor of its motion. But we do understand, Your Honor. Thank you.
All right, thank you. Any questions on that, Mr. Pryor?
No questions, Judge. Thank you.
Okay. The next issue that I think we need to raise would be the motion to continue, because I know it'll get into the middle of that when we're doing the venue motion, but there was a motion the state filed to sequester, and there was a motion then to continue the hearing on that. So I want to be heard on that motion to continue the hearing on the state's motion, Mr. Pryor.
If I may, Judge.
Yes.
Judge, I took the liberty of spending the entire weekend putting together a brief on what I think are the pertinent points. I'm not going to belabor them. If the court looks at my reply, you will see there are a number of issues that come into play. My reading of the motion to sequester only occurs after the court has decided, one, whether there's a change of venue, and two, where that venue change occurs. At that point, the state's motion to sequester becomes ripe at that point. It's a premature motion. The other issue is this, Judge. If you read my reply, there are a significant number of financial factors that go into whether this court should sequester jurors for what is likely to be a 2-month trial and the cost of that. And before I know where the trial will be or the jurors would potentially come from, what county, I can't do a fair assessment financially. And it's completely unfair. Mr. Wood filed this on the 29th. 6 days later, I'm supposed to address a motion when, frankly, Judge, my venue motion has been sitting out there for 2 months, and Mr. Wood filed his response 6 days ago. So it's a little unfair, it's premature, and I think the arguments I made in my reply speak for themselves, Your Honor.
All right, thank you, Mr. Pryor. Response from the state on the motion to continue.
Thank you, Your Honor. I would note that the motion to sequester a jury is not dependent upon the outcome of a change of venue. The state will be asking and has asked for the jury to be sequestered no matter where we are. So whether the court today changes venue and we have this trial somewhere else, or transfers trial, I should say, whether the court decides to change venue and then bust the jury back, as the state has recommended, if the court feels that it's necessary, or whether the court decides that Mr. Pryor hasn't met his burden, because it is his burden today, and that the change of venue doesn't happen, we're going to be asking for a sequestered jury to the state. That's a sunk cost. So the costs that the state is concerned about and will be concerned about are the additional costs of changing venue. And that's why we've made the request that in the event the court, out of an abundance of caution, decides to transfer trial, that we bust them back. In terms of this unfairness issue, I'd note that Mr. Pryor keeps complaining about the lack of a brief or reply. He never filed a brief in support of his change of venue. I'd note that this binder of documents he's talking about was delivered to the Fremont County office this morning. I don't know if we're supposed to print those off. I'm still waiting to get my copy of it, which I'm sure I will soon. But so this idea of unfairness, it's a little out of place. Your Honor, the issue of sequestering a jury does dovetail with change of venue, and it should be allowed to be heard today.
Judge, in reply, and I'll be very brief, Mr. Wood in his pleadings on the 29th, 2 months after I filed my change of venue, indicated that he's not objecting to a change of venue. So at this point,
Mr. Pryor, I disagree. I mean, there's some statements in there that, to avoid appeals, et cetera, they may agree to that. There's also a pretty clear statement in his pleading that they believe they can get a fair and impartial jury in Fremont County. So that's an issue, still needs to be determined at the change of venue motion. And I don't see that as a stipulation at this point. I mean, that we may get there, but I think we have to have that hearing first to determine what the state's position is on that issue.
Well, Judge, again, if the court's going to look at this in terms of financial factor, where exactly are we going to derive this sequestered jury from, and what county are we going to derive it from? And to give me, in reality, a couple of days to prepare the financial information to address this sequestering the jury is just blatantly unfair. I would point out in Mr. Wood's response when I delivered my notebook to everybody, I had delivered several weeks ago the same items on a thumb drive. I hand delivered it to Ms. Blake, and I hand delivered it to the court, and it's the same documents with the exception of a couple of additional things that I just received as before. And the notebook I provided is in response to this court's direction to us that we are not to broadcast items that we find might be influencing how the jury and potential jury would look at this. So I'll explain the notebook and I'll explain, but all of the documents have been provided, and they were previously provided probably 6 weeks ago. So Mr. Woods, I don't appreciate the argument.
Well, all right, I'll go back on that point. Really, the argument kind of stemmed from something that you brought up at the prior hearing, Mr. Pryor, where you said that their late filing just before the status conference was some sort of gamesmanship, to which I disagree. I've dealt with both Ms. Blake and Mr. Wood on many occasions on many criminal cases, and don't find them to be prosecutors that are playing games in any sort. And I think that's what kind of started this line of personal insults to the attorneys back and forth. And I admonish both of you that just keep things professional here. I'm not sure what the late filing reason was. On the motion to sequester, I know that it was filed on the 29th of September. We're now on the 5th of October. According to Criminal Rule 45C, motions need to be filed at least 7 days before hearing. And so that's one reason I'm looking at to grant the motion to continue on the issue of sequestering a jury. But I think more importantly, going to the point of the substance of that motion, I think it is premature because the decision needs to be made as to venue. And that would actually, it's not technically change of venue, it's the transfer of the trial if that does happen. Where that would be and how that would be done is only going to be determined after we make the decision based on the pending motion today. So I still understand the state's request, and we may need a future hearing on that, or the court may be able to determine that from what's heard today. But in terms of a separate hearing on sequestering the jury, I think it is premature. The other factor I'm looking at is the fact that we don't even currently have trial scheduled in the case because we need to get through this venue motion. And so for those reasons, I am going to grant the motion to continue on the sequestration issue. That motion then will be kept under advisement until such time as it can be heard at a future date. So that'll be the ruling on that. So council, that'll bring us up then to the motion we're here for today, which is the motion filed on July 21st, which is filed as a motion to change a venue. The court would note that's filed under Criminal Rule 21, which is a transfer of trial. So to be clear, the venue itself of the case does not change, but the location of the trial is what we're talking about, whether or not that should take place in Fremont County or not. And I'm prepared to hear argument on that issue today. So Mr. Pryor, are you ready to present argument in support of the motion? And then I'll ask the state if they're ready to respond on that.
Yes, Judge, and I will be calling my first witness, Mr. Bryant, when the court directs me to start.
All right. Who's going to be arguing in opposition on behalf of the state on this?
Your Honor, the state would, and with due respect to the court, the state does have a standing objection to holding any hearing which may affect the trial rights of Lori Vallow Daybell while her case is stayed and while Mr. Daybell has waived his speedy trial. We understand the court's ruled on that. We're not making a motion, just putting that objection on the record.
Very well. Objection so noted. As we get started here, I do think it is worth pointing out, wouldn't typically ask for something like an opening statement on a motion, but I do want some clarification if I could. I think before we get into argument on the state's position here, because again, there was some talk that maybe the state is either conceding or stipulating that trial should be transferred. However, I'd note in the state's response also, there was a pretty unequivocal statement you've got on paragraph 6, page 5, that says the state asserts that the citizens of Fremont can provide fair and impartial jurors capable of following instructions from the court. So I guess I'd like some clarification on where the state stands on this issue before we get started. Mr. Wood?
Sure. Absolutely, Your Honor. And I would note that the state never said it stipulated or conceded that a transfer trial was necessary. What the state has said is, one, we do believe that a fair and impartial jury can be found in Fremont County. We don't believe that the defendant will be able to meet that burden. Two, however, we do recognize it's a matter of discretion for the court, and as long as the court reasons it out, that decision should be upheld. What we've said is, in an abundance of caution, in the event that the court decides to transfer trial, we won't object to that if we can follow the code and bus the jurors back in to Fremont County, hold the trial where venue was proper, which I would note is specifically provided for in statute. I'm not making that argument right now, just that's the state's position, that if that's the case, and we certainly don't object to that out of an abundance of caution. But as to whether or not a transfer of trial is necessary, no, we don't believe that it is.
Okay, I appreciate the clarification on that point. So with that in mind, then it will be a contested motion. So Mr. Pryor, it is your motion. If you'd like to call your first witness, then you may.
Judge, I would call Mr. David Bryan from Ironwood Insights, if the clerk would swear him in.
All right, Mr. Bryan, if you'd please raise your right hand, I'll have the clerk administer the oath.
Solemnly swear or affirm the testimony you will give in the pending cause will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you, you can lower your hand. As we get started here, Mr. Pryor, I would ask that you keep in mind the admonishment I gave previously in terms of any specific references that would be particularly inflammatory or otherwise that may further compound this issue. We can do things not off the record, they'll still be on the record, but in a closed portion of this hearing. So I'd ask you to keep that in mind when you're eliciting responses from this witness. And with that in mind, you may inquire.
Mr. Bryant, would you state your name and spell your last name for the record, please, sir?
David Allen Bryant, B-R-Y-A-N-T.
Mr. Bryant, how are you employed, sir?
I am the Vice President of Analytics at Ironwood Insights Group.
And what is Ironwood Insights Group?
It's a full-service marketing research firm based in Arizona.
Okay, and you were retained to do a survey regarding the Lori Vallow, Chad Daybell case. Is that correct?
Correct.
And what steps did you take as part of your process to conduct that survey?
Well, the first thing I did was I did a literature search on media so that I was aware of all of the various names and people associated with this case. I then developed the questionnaire, and that questionnaire was sent to Mark Means. I don't know if he shared it with you or not, Mr. Pryor, but we then received some corrections back on the questionnaire. Once that was approved, we then programmed the questionnaire for both telephone and internet. And we administered that survey between February 15th and February 28th earlier this year in 2021.
Okay, let me talk a little bit about your experience in conducting these sorts of surveys. Can you provide us some background information in terms of your experience in doing these sort of things?
Yes, I have been doing marketing research, survey research, polling research since 1980, when I originally started working for Dr. Richard Worthland, who was Ronald Reagan's pollster. So I've been doing this for over 40 years and analyzing statistics and designing questionnaires and preparing reports based on those survey results.
So you have done this for a significant amount of time, have a significant amount of experience. Is that a fair assessment?
Well, I like to think so, yes, 40 years.
Is there anything that, as part of this survey, that you deviated from in terms of the standards that are put upon people who conduct surveys in your particular business?
No, we adhere to the standards of APOR, the American Association of Public Opinion Research, and the Insights Association. These are standards for maintaining confidentiality of respondents and the way the survey was developed. It's developed to be unbiased in terms of its questions and the sequence of the questions. And so, no, we strove to adhere to the highest standards, which is, in my opinion, the APOR standards, the American Association of Public Opinion Research.
Now, previously, last week, you provided me a copy of the study and the questions. Is that right?
Correct.
And Judge, those questions in that study were submitted to the court as exhibit. I believe it's exhibit number 10. You and I discussed the Ironwood Insights report. We discussed the survey, and the copy you provided to me was a true and accurate copy of the survey that was conducted in this particular case. Is that correct?
Correct.
Judge, I would move for admission of the Ironwood Insights report and survey. That's marked in the booklet that I provided to counsel and to the court and to your clerk as exhibit number 10 in my notebook.
All right.
Your Honor, the state of Jackson would like to ask some questions in aid of objection.
All right, go ahead.
Thank you. Mr. Bryant, I'm not going to get into any of the specific findings of your survey as I ask these questions. But I do have a few questions. You did say that you provided an initial questionnaire to Mark Means and he provided corrections. Is that true?
Yes,
Mr. Bryan, are you familiar with the standards set forth by the Pittsburgh Press Club versus United States case for admitting surveys and polls into evidence?
no,
Okay. Are you aware that when a survey is supposed to be admitted into evidence, that the survey must be conducted independently of the attorneys involved in the litigation?
no,
Okay. I want to ask you a couple other questions. Go to the admissibility. Again, I'm not going to ask you any of the substance of the survey. In your survey, how many counties did you conduct a survey in?
4.
What were those counties?
Bonneville, Fremont, Jefferson, and Madison.
Okay, and what percentage of the people surveyed were in Fremont County?
Judge, we're going beyond the scope of his objection. At this point, he's questioning my
This
witness.
goes directly to admissibility.
All right. And before you jump in, counsel, give me an opportunity if there's an objection. The issue here is admissibility. Exhibit 10's been offered. There's been an objection. Without getting further into cross-examination, which this is becoming, Mr. Wood, what is the grounds for the objection to Exhibit 10?
This poll is irrelevant, Your Honor.
And what's that based on?
This poll is a combination of a survey of Bonneville, Fremont, Jefferson, and Madison County. We are here today for the sole purpose of determining whether or not Fremont County is an appropriate venue. And yet this poll does not provide survey results simply for Fremont County. It's a combined poll. Now, Mr. Bryant may have had a reason at the time to do that. However, we're not here today to determine if Bonneville, Madison, Fremont, and Jefferson combined can provide a fair and impartial jury, just Fremont County. And so where this poll has all these other results from other counties, almost 90% of the results are from other counties. And it's not divvied out by county. This poll is irrelevant this survey and report are irrelevant to today's proceedings.
All right,
Also, this poll does not meet the standards met and Mr. Pryor has not even made an effort to lay the foundation required by Pittsburgh Press Club versus United States. So there's also a foundation objection.
All right, your response to those objections, Mr. Pryor.
Judge, to suggest that I'm supposed to limit my survey to one particular county is ridiculous. And to suggest if he wants to make the argument that because Fremont was only a portion of this survey, that the results are invalid, I'll be dealing that with Mr. Bryant. As far as the Pittsburgh case that he refers to, Judge, the survey, if you read the case, it says that the attorney is involved in the actual polling. The attorney's intimately involved in the case. To suggest that Mr. Means or myself cannot make suggestions to Mr. Bryant in terms of what areas we would like to explore for purposes of a survey is absolutely ridiculous. And Mr. Bryant's going to address those.
All right, there's a pending objection. Counsel, I'm going to take this under advisement for just a minute and review that case. I've seen the case, but I haven't read it recently. So I'm going to take a moment, take a look at that. After I've reviewed that case, I'll come back on and make a ruling on the objection as to foundation.
All righty. So they are in a breakout session. So I guess we are just going to have to wait. David Bryant was the one who conducted the poll to see if they could hold the trial in Fremont County. I've got myself muted, you guys, during this, so you guys don't have to hear me cough and whatnot. But yeah, so far, I mean, I'm gonna side with Rob Wood right here. Sensible Crime says, whenever I hear breakout session, my mind goes to makeout session. That's funny. Yeah, all this time and money. But I do think that they are going to probably keep it in Fremont County. I haven't seen all the comments. I have been stepping away, so yeah. Betty says Mr. Bryan is trying to stay as neutral as possible. Yes, and I seen him shaking his head. Yep, like when Rob Wood had said that most of this information was coming from the other counties and not Fremont County. He was like, he raised his eyebrows and shook his head. Yep. And it's true. What Rob Wood is saying is this is regarding Fremont County, not the other counties. So if they want to change venue, they've got to show more or less that they can't get a fair trial in Fremont County. So I guess we're going to have to wait and see. They're gone into a breakout room for whatever reason to argue about whatever. But I think we're going to be seeing a lot of this breaking out into a breakout room. Oh, thank you, Judy. Canadian law and US law, as much as some of the laws are the same, there's a lot that are different. So, I mean, what I can say for sure that I know, I will say, but if I don't know, because it's totally different laws for some things between Canada and the US. I wish Canada would adopt more of the US rules in a lot of ways, like especially in criminal law, but it is what it is. But I do try and explain it the best that I can. So thank you for that. Yeah, Linda's really good too. Linda is also a fellow Canadian of mine. She's out on the West Coast. I'm on the East Coast. She's on the West Coast. And she really breaks things down too. She gets a lot more in depth. She does a lot more research on US law. Mine is all from obviously the work that I've done over the last 30 or so years working in the field. Is where most of my knowledge is coming from. Whereas Linda goes beyond that. Okay, we're back.
All right, council, we'll be back on the record here. The court has considered an objection to the admission of defendants exhibit 10. The state cited the Pittsburgh Press Club case. Courts reviewed that, which raises the issue of whether or not a survey would be admissible if it is material, if it's more probative on an issue than other evidence and has circumstantial guarantees of trustworthiness equivalent to those of the class exceptions they talked about in that case. And then the proponent of admitting that has the burden of establishing the elements of the admissibility. So at this point, the objection was based on relevance and foundation. On the relevance issue, I do find that for purposes of this hearing, there's been a foundation, it's been established that it may be relevant, subject, of course, to cross-examination if Mr. Wood believes there's issues with the way it was conducted. In terms of the foundation, at this point, I would indicate, Mr. Pryor, I don't believe there's been a sufficient foundation laid for the admission of that, but I'll allow additional foundational questions if you have those from your witness before making a final ruling.
Okay. And Mr. Bryan, I want to start again. Can you hear me, sir?
Yes. Can you hear me?
Yes. So at this point, the survey that was conducted by your organization was done in the ordinary course of your business from your company. Is that correct?
Yes.
And nothing deviated from the standard procedures that you applied and the standards that are set out by your trade and organization. Is that correct?
Correct.
And you conducted the survey. Now, in regards to the questions, ultimately, Mr. Means did provide you some suggestions, but ultimately you formatted and put together all the questions yourself through your organization. Is that right?
Yes.
And then those questions were transmitted out on a variety of medium. Is that correct?
Correct. Both. We conducted the survey by telephone and by internet, by an invite to a web survey.
Now, based on the size of this survey, and before we get into that, when we're talking about the percentage of error or the percentage that would apply to a particular survey such as this, how much of a percentage of error or a deviation is there on a survey such as this?
The traditional explanation in a beginning statistics class is you assume that responses are 50-50. 50% said yes to this or 50% said no. So based on that 50-50, we had a total of 177 completed surveys, which yields a sampling error of plus or minus 7.3%. That table is actually included at the end of the report. As you move towards further extremes, as numbers become 60-40, 70-30, 80-20, and so on, then that sampling error becomes smaller and smaller.
Well, that brings up an interesting point, is that part of the questions and part of this survey was to decide and find out what people's feelings were regarding the Chad Daybell, Lori Vallow case, correct?
Yes.
And one of the questions obviously was whether or not people in the survey thought that Mr. Daybell or Ms. Vallow were guilty. Is that correct?
Correct.
And the percentage,
Objection, we're getting into the substance of the poll without it being properly admitted.
I don't need to admit it yet.
Well, if we're going to testify off of it and the results, then it's been offered and we need to get a ruling on the admissibility. So I've allowed for additional foundation. Do you have any additional argument on the objection to the admission of that survey, Mr. Wood?
Yes, Your Honor, there are 7 factors that Pittsburgh requires. So far, Mr. Pryor I do believe he has established Mr. Bryant as an expert. However, he has not met any of the other requirements. In fact, he has, I would argue, actually gone against some of those requirements. And so we still object. He has not laid the proper foundation for this poll or the results to be admitted into court.
All right. At this point, I have considered that objection in light of that Pittsburgh Press Club case. I would note that the question here is not ultimate admissibility at trial for either a jury or a court to consider on the ultimate issue that may go to the results of the survey, as was the case in there. This is a hearing as it relates to argument regarding publicity in a venue motion. And so based on the context of where we are, the court does find that for purposes of this hearing only, the survey will be admissible, of course, subject to cross-examination. Mr. Wood, if you have an issue with the way it was conducted. So the court will allow the admission of exhibit number 10, and that will be admitted into the record.
Thank you, Judge. May I continue?
You may.
And Mr. Bryant, so we were on the subject. I'm sorry, I just had a hesitation there. Mr. Bryant, we were on the subject of the survey that was conducted in this particular case. And one of the areas of the survey addressed the issue of whether or not the people who responded to the survey felt that Mr. Daybell or Ms. Vallow were guilty. And can you talk a little bit about the response that you elicited from the survey?
Yes, the specific wording of the question was, and this is question 9, if you were to say you lean one way or the other right now about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? Now, from the 177 respondents, we had 82.4% said they were guilty.
Okay.
And only one person said they were innocent. we had a very, we had 3.4% said they were innocent until proven guilty, and 11.4% said that they needed more information before they were able to answer the question.
Okay, now, in applying the margin of error on this particular question, 82%, what is the range of possibility? You had previously discussed that as you get higher up in the level of percentage. Now, we're talking a situation where 8 out of 10 people from Madison, Fremont, Bonneville, and Jefferson County determined 80% of those people in the survey from those particular counties determined that Mr. Daybell and Ms. Vallow were guilty. What's the margin of error? How high could that number actually be, given the margin of error that you would, from your experience, apply in this particular case?
Your Honor, I'm going to object to relevance where, again, this doesn't just apply to Fremont County, and we're dealing with multiple other counties.
Judge, you've already ruled on that. Can I go forward, please?
I'll overrule that objection. Go ahead.
Again, sir, what is the margin of error when we're talking about 8 out of 10 people, more than 8 out of 10 people already determining in this particular district that Mr. Daybell is guilty? What's the margin of error, sir?
5.8%.
So if we apply the 5.8 to the 82 point, what percent?
82.4.
Now, my math may be a little off, but I come up with 88% given the high end of the margin of error. Is that fair?
Sure.
Okay. Well,
Close.
5.8 plus 8.4 is
Well, 82.4 plus 5.8, yes.
in north of 88% of the people believing that Mr. Daybell is guilty. Is that fair?
Yes, but it also goes the other way. It
And
goes,
I'm going to talk about that. It can go the other way as well. It could go down to 77 or 76 something percent, correct?
correct.
Now, in your experience, and you talked about over 40 years doing this, how often have you run into a poll that was so slanted in one particular direction?
Well, it does occur. If you ask someone how satisfied they are with their new car, 82% might say they're very satisfied with their car. In this case, this is a very large percentage of people who believe that Lori Vallow Daybell and Chad Daybell, well, they lean towards their guilt.
Okay. Now,
It's
I'm
a very
sorry.
high percentage, yes.
So you would consider this a very high percentage.
Yes.
Okay. Now, one of the other questions applied to whether or not Ms. Vallow and Mr. Daybell could get a fair trial, correct?
Correct.
Now, taking into consideration that over 82% believe that Mr. Daybell is guilty, one of the other questions you asked is whether or not he could get a fair trial. What were the responses in regard to that?
Well, we had 22.6% said that they definitely will receive a fair trial in Fremont, Madison, Bonneville, or Jefferson County. And an additional 37.3% said that they probably will, which is a total of 59.9%, almost 60%, or 6 out of 10 respondents felt that they would receive a fair trial in one of those 4 counties.
Okay. So I'm a bit confused. 82% say that he's guilty, but in spite of being guilty, he'll still get a fair trial. Is that what the polling seems to suggest from the folks in Jefferson, Fremont, Madison, and Bonneville County?
Correct.
Okay. Now I want to talk about particulars by way of county, and Mr. Wood brought this up. What are the percentage of respondents from Bonneville County?
55.4% of all the respondents were from Bonneville. Obviously, that's where we were able to get the most respondents.
And obviously, that's a significant population in Bonneville County as well, correct?
Correct.
We're talking somewhere around 120,000 plus people, correct?
I can't verify that. Sorry, I didn't verify those numbers before getting on this.
And obviously, if you're talking about Boise, you're talking about a market it's not as big of a market as you would find 500,000 people in the Boise market, correct?
Well, that's correct.
Objection assumes facts, not evidence.
Sustained. I'll strike that answer.
Okay. So at this point, what were the percentage of Fremont County?
We were only able to obtain 10.2% of our 177 respondents. So about 18 people were from Fremont County.
Does that change your factors in terms of the margin of error any?
Well, not on the overall survey responses of 177, no, but if we had to just analyze the 18 people in Fremont County, yes, it would create very large sampling errors.
Right, right. So the idea is not just to limit yourself to Fremont County. The idea is to get an overbroad spectrum of people from a variety of areas to get a more accurate polling of what people's beliefs are. Would that be fair?
Yes.
Okay, so what did we do in Jefferson County? How many people over there?
Well, we received 15.8%, about almost 16% of our 177 are there in Jefferson County.
And then how about Madison County?
18.6%.
Okay, so the people as a result of this survey were predominantly from Bonneville County, is that correct?
Correct. Well,
And
over 50% from
Right.
all 4 counties came from that one county.
Right. So predominantly the idea here, and obviously you're the expert in this, is to draw from a large swath of people to get a more accurate representation of how people in Eastern Idaho feel about Mr. Daybell and Ms. Vallow. Would that be fair?
Well, that was the objective, yes, to collect information from all 4 of those counties.
And the cumulative information only provides at 80%, all of the cumulative counties and the information that was obtained provides a margin of error of just a little over 5% then, is that correct?
Well, on that one question where it's 82% who said yes, they leaned towards the defendants being guilty.
Right, okay. Judge, I don't have any further questions. I'll defer to counsel at this point.
All right, Mr. Wood, cross-examination.
Thank you, Your Honor. Mr. Bryant, thanks for being here. I want to talk about the universe you chose to conduct your poll. You did state, correct, that your participants needed to be at least 18 years of age, and either have a valid driver's license or be a registered voter in Idaho living in Bonneville, Fremont, Jefferson, and Madison counties, correct?
Correct.
And you did that to make sure that the people you polled were potential jurors, correct?
Correct.
Okay. Now, I want to talk about, you said Mr. Means gave you suggestions on questions.
Yes, I wrote the question, and I have to tell you, thank you for asking that. The one big change that Mr. Means gave is he wanted to make sure that the word Vallow was included in Lori Vallow Daybell's name.
Okay, but so he did participate at some level in the creation of the questions.
Yes, I did not include Vallow in Lori Daybell's name.
And did he make any other suggestions to you?
I don't recall that he did, no.
Okay. I want to talk about your representative sample. You've said that 10.2% of the individuals polled came from Fremont County, correct?
Correct.
And that, according to my math, is about 18 people. Is that correct?
Yes, I actually have the numbers right here. Actual numbers, if you don't mind.
That would be great.
We actually have achieved 98 out of Bonneville, 18 out of Fremont, 28 out of Jefferson, and 33 out of Madison. I can repeat those if you need me to.
I've got it. Thank you. You've been conducting surveys and polls for, you said, approximately 40 years.
Correct.
How many times have you polled as to the guilt of a criminal defendant in an area where a juror could be called?
Twice before.
Twice before. So this isn't done regularly, is it?
No. I have to admit, most of my research is in healthcare, public policy.
Okay. And so in doing your poll, let me ask you this, are you familiar with, did you study any census numbers to get the relative populations of the counties you polled?
No,
Okay. And you said that you sent an invite out for the poll online. Is that accurate?
correct.
And so, and how did people respond to that? What was the methodology for sending that out, and how did people respond to it?
We contract with a sampling firm, specifically Dynata, which is one of the largest in the United States. They're based out of Provo, Utah. And Dynata, we requested panel sample meeting. We identified the criteria of over a certain age, driver's license, registered voter in those 4 counties. They told us how many they had where they had email addresses, and they told us how many they would have where they had telephone numbers. So when they had email addresses, we sent them an invite indicating that we were conducting a poll with residents in those 4 counties. And if we were able to get a response by web via an online survey, then we collected those. If we had both an email address and a telephone number, and they did not respond to the web invite, we then followed up with a telephone call. If all we had was a telephone number, then we started out conducting by making telephone calls.
Okay. In the email that was sent out, did it identify what the subject of the poll was?
Yes,
Okay. So someone who is interested in that issue might be more likely to take that poll, correct?
that's correct.
Okay.
I mean, we did not say it was a murder trial in eastern Idaho. We just said we're interested in your opinion about a local a court case that you may or may not have heard of.
Okay, so it didn't identify it by the words Vallow or Daybell?
No,
All right. So let's get to, we're here today, Mr. Bryant, to determine if jurors in Fremont County are able to be unbiased in a jury trial. And so as I look at your poll, I cannot read this and get information specifically about jurors in Fremont County, correct?
that is correct. Because we were I'm sorry to interrupt, but we were requested specifically by Mr. Means to conduct the survey in all 4 counties.
All right. And he did not request that you divvy that up county by county, correct?
That's correct.
Okay. And so if I want to poll and survey potential jurors in Fremont County, well, let's strike that. Did you do any type of county to county comparison in the numbers you received?
No, I was not requested to do that.
Okay. And I think you testified earlier, you're not familiar with the population size of Fremont County, correct?
Correct.
Okay. Really quick, was this poll conducted, do you know if it was conducted on behalf of Lori Vallow, Daybell, or Lori Vallow, Daybell, and Chad Daybell?
Wow, my understanding is that it was being conducted on behalf of both.
Okay.
That's my understanding.
Okay. And when you asked the questions in your poll about guilt, say question 9, you didn't separate Lori Vallow and Chad Daybell, did you?
No,
So again, and sorry, I kind of got off on a little bit of a tangent there, but if I want to, again, I can't look at this poll and know and separate information about Fremont County without it being combined with information from those other 3 counties.
Well, I could do that, but given that we only have 18 respondents from that county, your sampling error is going to be huge. And I usually, as a rule of thumb, we don't put forth results for just anything under 25 respondents. And with only 18 in that particular county, the numbers would have very large sampling errors.
Okay. And so would you agree with me that 18 individuals is a very small amount of individuals to poll on an issue like this?
Well, if I'm looking at just that one particular county, yes, but the objectives that were given to us from the research specifications were not to just survey just one county.
Sure, and I understand that. And the questions I'm asking are not necessarily what you were asked to do. We understand you were given a commission and that you followed that commission. I'm not questioning that. It's the applicability to Fremont County. And
well, with only 18 respondents, I would not apply the results from those 18 respondents to reflect the entire opinion of residents in Fremont County.
Thank you. I have just a couple more quick questions. I would note that your question 1, it reads, are you familiar with any crimes that happened in the Rexburg area over the last couple of years where 2 or more people were killed? That's the question, correct?
Yes.
And you would agree, would you not, that the moment you say the word crime, you imply that someone's guilty, correct? Because crimes don't commit themselves.
Well, you're getting into semantics here, Mr. Wood. I guess
Okay.
that's the language I put in the questionnaire, and
Okay.
nobody objected.
Did you ever ask anybody if they believed that individuals are entitled to a presumption of innocence before proven guilty?
No, that was not the objective. However, we did have that as a response category that had been assigned to question 9. When you're reading just for clarification, when you're doing a web survey, these were all what we call closed-ended questions. And so when someone saw the question 9, if you were to say you lean one way or the other about the guilt or innocence of Lori Vallow Daybell and Chad Daybell, which way would you lean? All the respondents saw the possible responses of guilty, innocent, innocent until proven guilty, and need more information before answering. And they had the option of saying, I don't know. So they saw those on the screen as they were conducting the survey. Similarly, if they participated in the survey via the telephone, the interviewer read those response categories to the respondent. And so there again, they heard the words innocent until proven guilty.
Okay.
Did that answer your question?
Somewhat.
Not exactly.
I understand a little more how the poll was conducted now. Based on the way these questions were asked, would you be able to separate out the bias against Chad Daybell as opposed to Lori Vallow Daybell?
No.
Okay.
I'm sorry. Yeah, we the only thing that gets to that is we have we have questions 3 and 4. Question 3, do you remember any details about this crime or the people involved? That was an open-ended question. So we didn't give them any names, but and so you can see in question 3, 39.2% mentioned Lori Vallow Daybell, 35.2% mentioned Chad Daybell. Those are what we call open-ended questions. I didn't give them a list of options to select from. people
Okay.
mentioned Lori Vallow Daybell or Chad Daybell.
Okay. Now, based on your answer that you can't separate the bias totally between Mr. Daybell and Mrs. Vallow Daybell, is it also fair to say you cannot separate the bias between Mr. Daybell and Mrs. Vallow Daybell in Fremont County?
Oh, definitely not. Not from only 18 respondents. No.
So, Mr. Bryant, with the way you're answering these questions, if you were to conduct a poll for the purposes of finding if a jury could be pooled in Fremont County only, you would have wanted to question a lot more than 18 people, correct?
Well, I would have, yes. Statistical rigor, rules of APOR would have requested or would require that we had at least 100 completes just from that one county.
Okay. I just have just a couple more questions. Did you have any help in conducting the survey from people in your firm?
Absolutely, yes. I had a project manager. I had programmers who programmed the survey.
And would you consider those people that work with you to be experts?
Well, absolutely.
Okay, that suffices. I don't.
Yes.
Were you aware of the purpose of the litigation when you conducted your poll?
It was originally mentioned to us by Mr. Means that yes, this was specifically the Fremont change of venue survey.
Okay. And again, you testified earlier that you're not familiar with the United States Supreme Court case, Pittsburgh Press Club versus United States.
Judge,
No.
I'm going to object at this point. This court made a ruling on that issue, and Mr. Wood is just trying to relitigate an issue that this court already addressed.
That's
Your Honor, I'm entitled to ask questions that go to the weight of the survey.
I'm making a ruling already, Mr. Wood. It's overruled. I think it is still relevant, so you can answer the question or you can re-ask it, Mr. Wood.
No, he did answer the question, if I'm correct, that he was aware of the purpose of the litigation, Your Honor.
And the
The
question
state this time has,
Mr. Wood, the question objected to is about the press club opinion. And I don't believe it was an answer.
well, he already testified to that, Your Honor. He wasn't aware of it. That's fine. At this time, the state has no further questions for Mr. Bryant. The state would make a second motion to exclude, though, based on Mr. Bryant's answers, that this poll for the purposes of Fremont County is simply not sufficient. I think he said he need 100 complete surveys, and there are only 18. So again, the state makes a second motion based on lack of relevance to exclude this poll.
All right, your response to that motion before we get into further redirect, Mr.
Yeah.
Pryor.
Judge, at this point, the survey was done in a 4-county area that included Fremont County. As a whole, and as a complete whole of 77 responses, Mr. Bryan testified that the margin of error is 5.8%. So as a whole, in counties that include Fremont, in counties that include Madison, in counties that include Jefferson and Bonneville. Now, the allegations in this case rise out of both Madison and Fremont County. To have this court order myself or Mr. Means to do a survey in Fremont, then do a survey in Madison, then do a survey in Jefferson, and then do a survey in Bonneville would be prohibitive. So my feeling is if the court wants to apply whatever weight to this survey it wants to apply, that's the court's prerogative. And at this point, the relevant argue is inapplicable in this particular situation. It's clearly relevant.
All right, I've considered the state's second motion to exclude after the testimony of Mr. Bryant. The issue that's brought up for the court is the small number of Fremont County citizens that were polled as part of this polling, a total of 18. The issue before the court is whether or not a fair and impartial jury can be found within Fremont County. And for purposes of this hearing, which is what the Exhibit 10 is being proffered for, and the issue as it relates exclusively to Fremont County, the court does find, based on the responses of Mr. Bryant, that Exhibit 10 will not be considered, both for lacking foundation and on relevance grounds, mostly based on his very candid testimony that he would not apply the results of the survey to Fremont County because the sampling error was too small and the margin of error would be potentially too large, and it would go against the standards of APOR, which are the standards he used to conduct the survey, with a result of only 18 participants on the survey. So I think clearly, having heard those responses, the court can't consider this survey as it relates to finding potential jurors in Fremont County. So the court is going to sustain that motion offered by Mr. Wood, and the survey Exhibit 10, although previously admitted, will not be considered in the court's determination on the issue.
And Judge, in response to the court, if I may, if you look at my change of venue motion, I am asking to move from Fremont County, but I specifically in my motion address the issue as it relates to the 7th Judicial District that includes Madison, Jefferson, and Bonneville counties. My motion for change of venue specifically says that this hearing and this trial could not be effectively held in the 7th Judicial District. So I would ask the court to strongly reconsider its position, as although this is Fremont County, I think the court is splitting hairs by saying yes, Fremont County, and but frankly, I was also moving for the entire move from the 7th Judicial District. And under the rule, I'm permitted to seek a change from a particular judicial district. So at that point, based on how I've pled this in my pleadings, I think it is relevant.
Your Honor, I would just very quickly respond. This poll did not include all of the 7th Judicial District. It left out Bingham County, which is a fairly large county, and a couple of other smaller counties. So the poll would still not be relevant.
Well, Judge, you know, I don't have to go over every entire county to do this. What I do is I take the largest county within the 7th Judicial District, who happens to be Bonneville. I take the 2 counties that happen to be where a significant number of these allegations arise, and I take the adjoining Jefferson County. So when I pled this, I included the 7th Judicial District in my pleadings, and under the rule for a change of venue, a transfer, a trial, I am allowed to select and plead that this particular judicial district is not appropriate. So I renew my motion, Judge, and ask the court to reconsider and allow this exhibit to be admitted.
All right, well, I've considered the arguments on the admissibility of this Exhibit 10. I've also considered the change of venue motion itself and Criminal Rule 21. And still the question before the court today, while Rule 21 does contemplate whether transfers should occur within the district or outside of the district, and that's part of a determination, the first question the court has to cross as a threshold before getting there is whether or not we are transferring this trial out of the current location of Fremont County. And so the issue is whether or not we could find a fair and impartial jury in Fremont County. We haven't made a determination yet that it's being transferred within the district. If it were there, potentially this would be admissible, but where we are right now is trial located in Fremont County. The first judicial question I have to get to is whether or not we're going to go outside of Fremont County, and then we'd consider where an appropriate place would be, a different county. And so based on consideration of all that, still with those responses we have and only 18 people polled within Fremont County, the court's not going to change the decision I've made that Exhibit 10 will not be admitted or considered for purposes of this motion today. So that'll be my ruling, counsel.
And Judge, I guess in my position, simply if the court is excluding the report for purposes of Fremont County, at such time, if the court decides that Fremont County is not appropriate and is looking at whether or not the 7th Judicial District is relevant, at that point, this report does become relevant at that point.
Well, that is a potential, Mr. Pryor, because under Criminal Rule 21C, under Parts 1 and 2, there may be a determination made as to whether it should stay within the 7th District or without. And I would reconsider the ruling if we were looking at potentially moving within the district. So for purposes of where we're at today, I'm not considering it, but your point's well taken there.
All right, and Judge, so at this point, I would reserve my ability to seek a motion from the court asking that the court would apply Mr. Bryant's report in the event the court moves this case from Fremont County, and it has to, at that point, under the rule, consider an appropriate judicial district.
All right, I'll just take that request under advisement at this time, depending on where we end up. So,
And I have nothing else for Mr. Bryant, Judge.
okay, thank you, Mr. Bryant. Then that'll conclude your testimony this morning.
Thank you. I'm free to leave the Zoom meeting.
You are. You can log off.
Thank you, Judge.
Thank you. All right, do you have another witness to call, Mr. Pryor?
I don't have witnesses, Judge, but this may be an opportune time to have a meeting to discuss my notebook and how I would present the remaining exhibits in a way that complies with the court's admonishment about unnecessary advertising. So I would like to have a brief discussion about how I intend to proceed with the remaining documents and then go forward from there if the court would accommodate that request.
All right, I think that that's a reasonable request. I think the time's good for that as well.
I would ask though if we could take a 5 to 10 minute break before that.
Okay, so here's what we'll do. We'll take a break until 10:30, at which time I'll ask the clerk to please set up a breakout room where I'll meet privately with counsel. I will have the court reporter take a record of the proceedings of the breakout room, and we'll discuss potential exhibits to be admitted in furtherance of the motion. So we'll be in recess for 10 minutes, and then we'll reconvene in the breakout room.
Thank you.
Well then. Okay, so it looks like they are taking a 10-minute break. I'm going to, okay, there we go. Okay, so the court is currently on break for 10 minutes. That gives everybody a time to run and go potty or make a coffee or something along those lines. So they're not going to allow that survey that was done to be admissible right now in this motion to change venue. The motion to sequester the jury is going to be continued because they don't even know where this is going to be held yet. And the motion to seal all this hearing that we are seeing today, they started off with that. The district attorney wanted this all sealed for us not to be able to see it. So the judge denied that, obviously, because we are seeing it. So that's what's happened so far. When we come back, they're going to continue with their arguments on the change of venue. So we are going on break for 10 minutes. I will see you all back here in 10 minutes time. Okay, you guys, I'm back. Okay, so I've just come across a couple more things that I want to share with you guys while we're waiting for court to resume here regarding the Brian Laundrie case. There's a timeline that's come out from Brian Eaton that came out of the video that an interview that they had last night with Cassie Laundrie. So on August 17th, Cassie said Brian flew back to Florida without Gabby for a visit. She says she saw Brian and also FaceTimed with Gabby. And then September 1st, Cassie says her parents showed up to her house with Brian. She said she did not expect Brian to be there. They arrived in the Mustang. September 6th, Cassie said she went to Fort DeSoto campground from 2 to 8 p.m. She says her mom, dad, and Brian were there. She says she did not know that Gabby was missing at that time. September 11th, she says, Cassie says she was contacted by police and has been cooperating ever since. And she says she has not spoken to her brother since. So what she's saying is she has not spoken to her brother or her parents really since September 6th at 8 p.m. when she left there. So that's what came out of that interview with Cassie last night. And like I said in my previous live this morning, you guys, I do believe that Cassie is telling the truth. I'm just checking around to see what else I can get here, you guys. Okay, so let's see what's coming out of the dog camp. Okay, so Lissa Chapman, who is Dog the Bounty Hunter's daughter, put out a tweet saying, keep in mind, there are lots of criminals on the run in these areas. Keep your distance, take a picture if you can, and call law enforcement immediately. Report all suspicious activity. It is possible we can take multiple felons off the streets while hunting for Brian. They're asking to look for distinctive features on the left side of Brian Laundrie's face, just down from the corner of his mouth where his beard starts, there's a mole. And the tattoo on his hand with the like the vine type thing. And there's also mountains on the side of his hand. Also, there's a bend in his right ear, near the top of his ear. There's like a crinkle bend. And it looks like he has some kind of mark on his right temple. So those are some of the characteristics that they're asking people to watch for. I would pull it up, but I'm scared to mess up my stream right now. Let's see what else I've got here for you guys. And he seems to have a mole just below the corner on the left side of his mouth, just where his beard starts. There seems to be a mole there too. And that tattoo of the vine on his middle finger and the mountains on the side of his hand like Gabby had. Okay, so let's see what else I can get. She just also posted, keep all possibilities open because they're not looking for a white truck. We are looking for Brian. So that just, I mean, to me shows that, again, that sighting was not Brian. I'm just looking around, you guys, while we're waiting to bring you guys more information on the Brian Laundrie, dirty laundry case. Oh, there's even some on Twitter here, free Brian Laundrie. It's like, oh my gosh, that is horrible. They're saying Brian was innocent victim of domestic abuse, and since his abuser, Gabby Petito, ran away, people are viciously slandering him. Wow. Some people, man. Like I said, I'd show it to you, but I'm scared of messing up my feed that I got set up here. Oh, let's see what else. Okay, let me see right here if I can get this. Okay. Let me copy this and see if I can't put this. I don't know if it's too big for chat, but I'm going to try and put it in chat. A link to the sister's interview. There it is there. So there it is there. I just put the link up, you guys. That is the link to see the full interview with Brian Laundrie's sister that was done last night. Yeah, Reddit has some really awful stuff. There's a couple of channels, I guess. I don't know what they call it on Reddit. I'm not on Reddit, but Friends of Brian Laundrie and Justice for Brian Laundrie. Now I'm seeing them pop up on Twitter too, that they are attacking Gabby, blaming Gabby. It's like, it is sickening. They're calling him a modern day hero in his ability to hide from law enforcement. They're calling him hide and seek champ of 2021. They're mocking the FBI. It's horrible, you guys. Hobbycat, I think there's a lot of people that are posting stuff that isn't true or coming forward, and I think that they could be in these groups that are supporting Brian Laundrie to send people on wild goose chases. Like, he's not going to come out and just be driving a truck and talking to somebody, and he knows he's wanted. He's going to be in hiding. He is going to stay in hiding. So for these people that are coming forward saying, you know, I don't think that the gentleman himself lied about possibly seeing Brian Laundrie, but I think there are people out there with these sick minds that believe that Brian is innocent of everything, that are setting up scenarios around the area to cause distractions, if you know what I mean. It's exactly what I think is going on. Brian is not going to show his face. There's too many people looking for him. The whole world is looking for him. The whole world knows what he's done. He's not going to take the chance of talking to randoms or being seen. That's in my opinion. I think at this point he is now hunkered down somewhere. Somebody is assisting him and hiding him out. Is exactly what I believe right now. I believe that for a time that he was on the run, and then when he seen the amount of resources that was being used to hunt him, I think somebody stepped up and is hiding him. And as we can see, I don't suggest you go there and join these Reddit pages, but if you go there and you see the amount of people that are willing to do anything for Brian Laundrie, who's to say that there's not somebody there that is hiding him out now? when they seen the mass search going on for him, it's like, okay, we got to get you here and we got to keep you hidden. Like, that guy is not going to show his face. Something's got to happen with whoever's helping now hide him out. I want to so bad do another read, you guys, but I'm just not 100% yet. I am getting there. And as soon as I feel 100% where I feel that I'm going to be able to concentrate and get the messages that I need to get from a read, I am going to do another read. But I do believe, and I'm getting this from my ancestors intuitively, and I'm looking at my Billy's picture right now, who it is his birthday, and he was murdered 20 years ago, over 20 years ago now. I know what I'm getting is right. And I'm getting that somebody is now helping him. I believe that they might have been helping him all along, but now they are harboring him. And with the vast amount of people, there's literally 4,700 people that support Brian Laundrie that think he's innocent. Okay, so let me see what else. Oh, thank you, Rosie. Yes, it is his birthday today, so I will be going to the gravesite later when we are done here. I sent you the link to her full interview. I'm also going to send you guys the link to this. Whoops. I can't send this. How come I can't share this? I'm doing something wrong, you guys. Go figure. Why can't I see it? Okay. I don't know why I can't link this, but if you guys, I'm going to retweet it, you guys. If you guys know my Twitter, head over and check on my Twitter page. I've just retweeted a post there, and it's Brian Eaton talking to the caller who called in that sighting in the white truck with Brian Laundrie. He has a personal conversation with him, so go over and check that out. Okay, Cindy, I just shared it on my Twitter. If maybe you can copy it from there and post it here, that would be great. Oh, thank you, Anne. Thank you, everybody. Shivani saying it is possible that Brian Laundrie would like to steal a vehicle. I don't think he's going to do that. It's just going to bring more heat on him and put him in a vulnerable situation, which I don't think he's going to do. He's going to stay right out of sight. He's not going to get a vehicle where he has to either dispose of it when it runs out of gas, or a chance going to a gas station to get more fuel for it. Dropping it somewhere, he could leave fingerprints where they could see which trail, like follow his trail type thing. He's not going to do that, you guys. Oh, Anne, I feel for you, my dear. Yeah, he was murdered 25 years ago today. Not today, sorry, March 5th. It was 25 years ago that he had been murdered. Rosie said 60 Minutes Australia even did a story on Gabby. Yeah, HLN also covered her. I think it was last night or the night before. They did a segment on Gabby also. Yeah, Shining Bearable says, I don't think he's got to steal anything. He has wealthy family. Oh, thank you, Cindy. It's all good. I mean, it is what it is. Nothing can be changed. I think somebody's helping him hide. I think he's at somebody's residence now and they're hiding him out, or a camper or something along them lines. Like I said, I want to do another read before I nail down what I think, but I do think that he is being harbored right now. I don't think he was at first, but I do think he is now. Okay, let me see what else I can get over here. Sorry, you guys, I can't see chat right now. I'm just checking to see what else I can find for you guys in update wise. Yes, everybody. Court is on break. They've been out for a bit now. So I know they were taking a 10-minute break and then they were meeting in a breakout room to go over some things that I guess one side or the other does not want to be brought out in the live feed. So there are going to be some things that we can't hear because they could jeopardize one side or the other. Yeah, if somebody is found to be hiding him out, they can be charged with aiding and abetting because it's all over the news. Like, yeah, I do believe that his mom and dad know where he's at. For I have children myself. Mind you, they're older than Brian. They're all in their 30s. One just turned 40. If one of my children were missing, I would be going crazy. There's no way that they are out in the backyard gardening and this and that, you know, trying to just live their best life with your son missing. If they thought that he was in danger and truly didn't know where he was, I think that they would be a lot more frantic and upset and doing a lot more than what they're doing. That's my opinion and my opinion only. Shining Bearable says nobody was charged for helping OJ try to run away. Well, that was seen on across national TV. I think they had their eyes on him. They knew exactly who was driving. They knew that the case. You can't really compare those two. I believe the last time Brian Laundrie was seen was on the 11th by a neighbor. History Underfoot asked, did anyone see Brian Laundrie after the camping trip? Yes, there was a neighbor that seen him on the 11th. That was the last time anybody's seen him outside of his family. So we are waiting for court to come back in session, you guys. Give me a second, please. Okay, there was a comment saying something about Brian Laundrie's family could be afraid of him. Absolutely, they could be. Like, put it this way, if he killed, and I believe he did, kill Gabby, somebody that he wanted to marry, said he was so in love with, and blah, 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 and didn't do things his way or what he wanted, and he kills her. Can you imagine would you go to sleep with somebody like that in your house? Hell no. There's a whole new meaning to sleep with one eye open. Okay, sis, check your messages. I just sent you a message. Thank you, Cindy. Mary says they're spending all their money on their goofy demon son. Oh, thank you, Drama. Yeah, Rebecca, I hear you there. I would be, oops, sorry, that's not what I wanted to put up. Okay, I'd be going insane if it was me, and I'd be helping any way possible. Rebecca, yeah. Like their actions aren't coinciding with their son being missing. That's just my thoughts on that. Jackie says, what about Sister Willow? Do you think she may know where? No, I don't. I totally believe her interview that she gave last night. I really totally believe that. Ha, check your messages, sis. Me and my sister are in a fight right now. We're in a fight on Messenger. I'm going to turn off my phone so she can't answer me back. She says, I love you more, sis. And I said, nope, I love you more. So now I turned off my phone so I can't hear. If I can't see it, that means I win. That just means I love her more because she can't answer me back now. Because I can't see anything that she sends. I turned my phone over and I turned off my volume, so I can't see her now. Oh, some of the things me and my sister do, you guys. You'd be you'd be surprised. Yeah. She was also asked by the police not to talk about the 1st or the 6th when she's seen Brian and her parents. And she did say that she hasn't talked to her parents either since 8 p.m. on the 6th. That their lawyers, okay, we're coming back into session, you guys. Apparently the laundry lawyers have told them not to communicate with her. But we are coming back now, you guys. So we're going to get ready for this. Oh, well, they were coming back. As soon as they come back, you guys, I will mute myself. Texas woman says, that's not nice. Yeah, we're constantly, when we're on FaceTime and stuff like that, when we go to hang up, we'll throw kisses back and forth to each other. And I'll say, I love you. She says, I love you more. And I said, no, I love you more. And I hang up. So so I win. Exactly, Judy. He's not going to put himself out there where he can be seen at all. Somebody is helping harboring him. I think Cassie has been pretty honest. I do believe that she thinks Brian did it. And I don't think she's going to say that, but, you know, repercussions of probably losing her whole family. She did kind of slip and say, well, you know, I'm going to lose my brother and my parents, because I think the parents are saying, you say anything against your brother and that's it. You're disowned or something. Now, I don't know if that was said, but I'm saying that could be what's going on in the background. Like, they could be very upset that she's even spoken. So they may be disowning her if she says anything. You witch. Sorry, guys. See, I can't win sometimes, you guys. Thank you for the super chat, though, sis. Oh, sorry, you guys, for having to mute again there, but that Mucinex, I should have waited to take that until after this was done, because it works. Oh, so now I got to look at what she, okay. Oh, I'm so sorry, you guys. That is disgusting. I'm telling you, that Mucinex works, and it works quick. I'm trying to stay one step ahead of this, you guys. Like, my sinuses have finally pretty much cleared out, but now it seems to be going down on my chest. So I started on the Mucinex, and it's like, oh, I didn't think it'd work as quick as it has, and I'm telling you, you guys, that stuff works. Yes, families can be toxic too. There's a couple in my family that I do not speak to, just for that reason, because they are toxic. Yeah, so that's why I keep muting, like, you guys. It's like, whew, like I'm making myself kind of want to throw up listening to it. But anyway. Oh, Marianne, no, I will definitely mute myself. It is disgusting. Like, I can't even deal with myself right now, listening to myself do it. There's the last thing I'll let you guys do is listen to that. Yes, the court is on short break. They almost came back a couple seconds ago there, you guys, so they will be coming back shortly. Actually, I have seen that that news crews have gone by with drones at Cassie's residence, and there's nothing going on there. They're leaving her alone. I truly, you guys, believe what she said. I truly believe she wants to come out and say what she knows, but she knows if she does that, she knows she's going to lose her brother. He's going to jail. But she doesn't want to lose her parents too, and be, without family. Like, and plus the police have told her not to speak about it. So, I mean, I feel for her. I do. Yes, I do too, Vicky. I totally believe her after that. And you guys know, I'm an intuitive, so I get feelings if something is not right. I still believe she knows a lot more, but I also believe that she's been told by the police not to speak about it. I also believe that she is in fear of losing contact with her parents too. Her parents have refused to talk to her since the night she left the campsite on the 6th at 8 p.m. So, I mean, put yourself in her position right now. I think she is going to follow what the police said and not speak anymore about, what happened on the 1st or the 6th. She said that her mother did bring Brian to her house in the Mustang. And I believe that's where she's going to leave it. Sorry. Because she doesn't want to lose her whole family. So let's just leave that be. Let's give her the respect for saying what she did say. And you can believe me or not, I believe she was being honest. I do believe she knows more. I do believe she may have overheard things on the 1st and on the 6th. But she's been asked not to speak about that. So you got to respect that. Deep down, history underfoot, I do believe that she is concerned with not having any more contact with her parents. Your parents are your parents. You don't get a choice, right? Your parents are your parents. Your family's your family. And yeah, her sole focus too is on her children and protecting them from, look at what's going on at the laundry house. She doesn't need that at her house either. And I do believe that she has no idea where Brian is. Yeah, so right now, if you guys do want to check out my bonfire, it's not a requirement. I'm not sure I'm even going to keep that bonfire site going for very much longer. I think I may change it up and go to a different provider for my merch, unless they come out with some new items that I've been inquiring about. I think I may just change. So if you do want to go over there and check it out, that's the link to it. You can check out what's there, see if you're interested in any of it. But I do think I'm going to be getting rid of that fairly shortly, that my bonfire site anyway. And I will probably take a couple months and get another site to provide my merch. Yes, it's a good season for the hoodies. And these hoodies are they're really soft. They're not the normal sweatshirt, rough type material, and they're very warm. They're like thick and they're warm. And very nice to the touch from what my sister, I don't have one personally. I'm not very much a sweatshirt person, but my sister has one of each, maybe even two of each. And there's the zip up hoodies, there's the pullover hoodies, there's shirts, there's racebacks, there's t-shirts. Yeah, there's another site that I'm looking at because you can also put the print down the arms. Yeah, I've also got support shirts there for YouTube support team. My Angels of Truth, I think it says Angels of Truth on the back, YouTube support team, with my emblem that you see here flashing on the front. But like I said, I think I'm going to be closing up this site shortly and going over to, there's another one, I don't want to mention it. It's not Teespring, it's another one that I've come across that has a lot better variety of things. And you can also do the writing down the arms. And that's one thing that I like about, and I've been getting a lot of requests for that. So I'm going to check it out. I've got a choice between a few. So yes. And if you do get anything, send me an email with a photo of you in it, and I will put it up on my community tab. Oh, Rosie says I'm going to order one or two. Yeah, if you want to order something from there, you guys, do it soon because I am going to be taking that site down. I'll give it until the end of October. And then after that, that site will be gone. I'm going to try and, like, this is I've got copywritten my logo here. So I'm still going to be using this logo. For the sweatshirts and shirts, you don't have the writing with the wings. You just have the wings on the back. And then the Above and Beyond Ancestor readings is in smaller print, either on the front or on the bottom. But I don't put the Above and Beyond Ancestor readings on the back right now, because I just liked seeing the wings. Postage and conversion will probably kill me, but it'll be worth it. Aw. Yeah, I just, there's a couple of other YouTube channels that I support. One is Steve Ronan. He does a lot of around the world abandoned places that he explores. I ordered his sweatshirt. I love it. It's warm and everything. And I think with the exchange and everything, it ended up and the shipping, it ended up costing me like $135. And then I just ordered one from CJ Faison, who does the Randonautica and ghost hunting and stuff like that. He's also a race car driver and owns a bunch of big companies. I forget what you call that, Delaware Auto. It's where they auction off cars. I just ordered one of his motivated sweatshirts, and that one ended up costing me like 120 Canadian with the shipping and everything. So it is more expensive if you're outside of the United States, and it takes a little bit longer to get it. So yeah, but that's Canadian. The Canadian ratio to US, I think it would have came to 69, 70, 80, about between $75 and $80 American. It would have came to with the shipping. Costed me like 110 Canadian. So $80 American costs me 110 Canadian. Oh, you did order them, Des? Okay, cool. Yeah, it's just too expensive for me to order them. I think I ordered the greenish color hoodie. I wanted to get the yellow one too, but it's just too expensive for me to buy from Canada. That would have been like $200 and something to buy both of them. But I do like supporting. There's certain channels that I do support, and I do help out with buying their merch. So yeah, Adventures with Purpose. I was going to get one of theirs too, and it would have costed me about the same, like $120 Canadian. And I know, I don't know the exchange, Rosie. How much is $50 Canadian for you? I think your money's worth a lot more than ours, even more than the US. I know England and stuff like that, their money is double ours. So if I want to buy 2 pounds, it's going to cost me, if I want to buy a pound, it costs me almost $2 Canadian for 1 pound. Oh, double. So it costs you double. It's almost like me buying like something from England costs like, to buy 1 pound costs me almost $2 Canadian. So it gets expensive. And then we pay more in shipping too, to have it delivered to Canada because it's international mail. Yes, they're still in recess. They almost came back a second or so ago. but they are still in recess. They should be back soon. It's been almost an hour, you guys. Oh, thank you, Barefoot. Barefoot Claire. Thank you. Like I said, I'm only going to have the bonfire site up until the end of October, and then it'll be taken down. So Rosie says plus $10 US shipping, so cost me. Okay. Yeah, see, the shipping for the one that I just bought, it was like $49.99 plus tax and everything else and blah, blah, blah. It came to like $59.99 or $55.99 with taxes and everything. Plus, it costed me $22 in shipping. So it came to like $110 Canadian. And that's $22.49 US. So by the time it's all said and done, my order came to, with the shipping to Canada, came to like almost $80 US, which came to like almost 110 Canadian. So yeah, like for the sweatshirt itself was $49.99, and I'm paying $22 for shipping. So almost half the price of the sweatshirt. So yeah, it does get expensive. So, but like I said, I do try and support the other channels that I do follow as much as I can. And the ones that I just can't afford to order more merch, I do throw them super chats. So I do my best. I do my part to support everybody. Does the hoodies run big or normal size? I think the measurements are also there, Real Angel. If you go to my bonfire site, in the sizing, there's a sizing chart there. And what you can do is just lay like a sweatshirt that fits you perfectly, or how you want it to fit. Just lay it out and measure it, and you'll be able to see how close the sizes are. But they run pretty much on point. I've got a couple of my shirts, and they've run on point. I'm like 118 pounds, 5'4", 118 pounds, and a small fits me all right, but I got a medium because I like really loose fitting clothes. Yeah, the measurements will be in US. Okay, I'm just checking around here, you guys, into Twitter. So if I can't see I can't see you right now. But I'm checking Twitter to see if there's anything else that's come out. Okay, so here's some more information that just came out on Twitter regarding when Brian had flown back during Gabby and his trip. Josh had asked him, can you please send me the explainer about the flight Brian took? The Laundrie family lawyer said Brian flew home to Tampa from SLC on 8/17. So that's August 17th, and returned to SLC on the 23rd to rejoin Gabby. To my knowledge, Brian and Gabby paid for the flights as they were sharing expenses. Brian flew home to obtain some items and empty and close the storage unit to save money as they were contemplating extending the road trip. Okay, so that's apparently why he went home, to empty a storage unit and to obtain some more items maybe that they wanted for their trip. This is what the Laundrie family lawyer is saying. And that he flew home on the 17th of August and returned to rejoin Gabby on the 23rd of August. Let me see what else I can get for you guys here. And yeah, apparently Brian and Gabby paid for those flights themselves as they were sharing expenses. Huh. Well, let's see what else. If there's anything else. I'm going to retweet that, you guys. So if you want to see it yourself, you can go to my Twitter. Just trying to find anything, you guys, that has been put out. Oh, crap. Huh. I wish I could show you this, you guys. I don't know if I can. Okay. You guys can go and check this out while we're waiting. I'll put it in chat here. Go and check that out, what I just posted. Oh, pretty kitty. It says a mountain lion found hanging out on a wall in Boulder, Colorado. Huh. Boulder is in Colorado, right? Denver, Colorado. Yeah, Colorado. Just hanging out, laying on. It looks like a fence almost between two properties, and he's laying along the top of it, just like a normal little kitty cat would do, but he's not so little. I just found that interesting. Oh my God. These guys are crazy. I'm also going to retweet that because I watched that last night. And I'm looking, sorry, you guys. I'm talking as if you guys can see what I'm doing. I'm looking at CJ Fazen's vlog. And he buys a car. I don't know if you guys have seen it. If not, head over to my Twitter. I just retweeted it. Him and Sunny Deeds get in this car that CJ had purchased. It's just a beat up old car. And they got like life jackets on and they're going through a car wash with the windows down. It is hilarious. You never know what CJ is going to do. So when I need a good howl, I go there. I just retweeted it. So if you guys want the link for it, if you want me to post it here, let me know and I will post it for you guys to go and check out while we're waiting for court to come back. I laughed so hard, you guys. I was coughing and laughing and blowing my nose and oh. Perry's excuse to miss court. Kitty cat scared me. Okay, so do you want me to post the link to that here, you guys? Because I will post it if you want. I just found it hilarious. If you want a good laugh. Here it is here. Oh, that's not even, wait a minute. Wait a minute. Oh, okay. Oh, how do I share this? Okay, wait a minute. I gotta go. I'm not very good on Twitter, you guys. So I don't know all the ins and outs on how to work this. I barely know how to work YouTube, for crying out loud. Who am I trying to fool? Okay. There. Okay. I'm going to... Oh my gosh, you guys. Okay. I'm going to post it here. There we go. There it is there. Oh, Cindy, thank you. There it is there. If you want to go and check that out, you guys, it is hilarious. Like, you never know what CJ is going to come out with. Like, there's such a serious side to this guy, but there's also a side like this that if you don't know who CJ Faison is, you're missing out. Just love him to death. When I need a laugh, this is what I go and watch. A lot of people tease him about the way he screams like a little girl when he gets scared, but oh my God, I get such howls and laughs. It's unreal. Oh, Rosie, you got to go and check him out. CJ Faison. Here, I'll try and get the link. If somebody could put... Oh, hang on a sec. Cindy, my love, or my sister, or somebody, one of the mods, can you get the link to CJ Faison's channel? Yeah, the only one that can post links here is mods. So if you're trying to post links, it's not going to go through. CJ Faison, hang on. I'll see if I can get it here. Okay, here he is here. Okay, I got it, you guys. Here it is here. And if you go here, this is his main channel. That's his main channel. If you go there, look in the description of his videos and you will see CJ Faison vlogs. Subscribe to that one too, because that's where you see all the funny stuff, behind the scenes stuff. He is just like, when you need a good laugh, you guys, you've got to go and check out his vlogs. Okay, I got to mute you guys because my sister, oops, I missed it. My sister was calling me. Sorry, sis. Yeah, if you go to his main channel, you will be able to see his vlogs. The link to his vlogs, it'll be in the description. Sis, try and call me back because I told you I had my phone off. I had my volume off, so I just seen that you were trying to call me. She tried to get one up on me, you guys. And she called me back and she tried to hang up saying, I love you more, and tried to hang up, but I got it in there and then hung up. Oh, that was funny. Anyway. Oh, whoa, just read the FBI raided New York Police Department Union headquarters. Why did they raid the Just read the FBI raided New York PD's Union headquarters. What? Let me go and check that. Fact checker. Okay. Yeah, they are taking their time. Okay, so this is what it says. The FBI raided the headquarters of the New York Police Department's Sergeants Union on Tuesday. A spokesman for the FBI New York office told The Hill that the agency is carrying out law enforcement action in connection with an ongoing investigation at the headquarters of the New York Sergeants Benevolent Association. Spokesperson declined to confirm the details of the investigation. The Hills reached out to the New York Sergeants Benevolent Union for comment. Asked about the raid, the New York City Mayor Bill de Blasio said during a news briefing on Tuesday that it was too much too soon to provide any details because he had just been notified. All I've been told is that the FBI has raided the SBA headquarters and it's in connection with an ongoing investigation, but we don't have any further details at this moment, de Blasio said. The SBA claims to represent about 13,000 active and retired New York Police Department sergeants. Ooh. Uh-oh. Oops. Thank you for that history underfoot. Yes, the court is in sidebar to discuss potential exhibits. So yeah, something's going on there. They did almost turn the camera back on a minute ago, you guys, but turned it right back off. So something else might have come up. Yeah, it makes me cough. Lady Hawk says, don't make Willow laugh. It makes her cough. Yeah, as long as I try and keep my very on federal charges bribery. Yeah, for those of you who didn't see the beginning of this, Barry Morphew, speaking of Barry Morphew, is going back to court on October 13th because the ankle bracelet that he is required to wear while out on bond cannot be tracked. Where he is staying at the Cushmans, just 100 yards or so from his old Puma Path home in Monarch Estates, they cannot get any GPS tracking and they cannot get any alerts because of there being no internet or very spotty internet connection there. So since the day after his release, they have not been able to confirm if he has been in that house or not. So this was made, the court was made aware of this the very next day after his release, that they cannot get, he could have taken that ankle monitor off and be gone to Mexico for all we know. because of the spotty internet connection where he is in Maysville at the Cushman's Airbnb, which is just a couple hundred yards from his old Puma Path home. The internet connection there is so spotty that they cannot track his ankle monitor. And on top of that, and I'm repeating this for people who weren't here at the beginning of this morning, he is also just hundreds of yards from the Ritters' residence. The Ritters are the ones that called in Suzanne being missing, who the girls and everything had called to go and check for Suzanne's missing bike, and who also had coffee and that with Suzanne at times. They're under the witness protection order. Barry is staying within a couple hundred yards of their home too. And they are feeling very uncomfortable, not safe, and they don't want to stay in their own home because Barry is staying just a couple hundred yards away at the Cushmans. Being that they cannot even track his ankle bracelet because of the internet connection, he could have gone over there and murdered them, and it would never show on his ankle bracelet because they can't monitor it. The internet connection isn't good enough to monitor whether he's even in that house, whether he leaves that house. So he could take off that ankle bracelet in that house and go to Denver if he wanted, and they would never know that that ankle monitor had been taken off because they're not getting any alerts. So he will be back in court. The DA is asking for a modification of his bail conditions. That is going to happen on October 13th, and I'm very surprised that hasn't been done ASAP, like the very next day. So since September 21st, they have not been able to monitor him to where he is. Also, they're going to be asking that he reside at 315 Poncha Boulevard in Salida. It's been shown that he is paying rent there at 315 Poncha Boulevard for Shoshana. So they're going to ask that there's an order that he resides there where he can be monitored. But this is not all going to happen until October 13th, you guys, and which means for almost 3 weeks, he is basically, he could be taking off that ankle monitor and they would never know because there's no internet connection to alert them that it's been tampered with. Can you believe that, you guys? A murderer who's being accused of first-degree murder cannot be tracked right now. Yeah, and he's living at the Cushmans, the Cushman's Airbnb, which is just a couple hundred yards from his old Puma Path home and from the Ritters, who are under a witness protection order. It's like ridiculous. I don't know why this wasn't back in court that very day when the courts were made aware that they could not monitor his GPS and they could not get alerts if he tampered with the device or anything. He should have been back in court that very day, the very next day when they realized this. So that's news that came out this morning too, that I did cover when we first started this live for the Daybell case. Sorry, you guys. I had to blow my nose badly there and cough a bit. So, okay, I missed another phone call. Uh-oh. Okay, they're coming back. I hear noise. Okay, they're back. I will be muting myself. About time, you guys. Can you hear me? They're back, guys. They're just getting everybody into the courtroom here. About time. I hope they had their lunch while they were doing that. Of course, they're waiting on Dumbbell. Sorry, you guys. I've just been checking things on my phone. I've got a whole whack of stuff that came in here. Okay. Okay. Once this gets going, I will mute myself and then I will go and take care of that. The lady with the dark hair is Lindsay Blake. She is the special prosecutor. Betty Smith says, where's Pryor? Well, they're late, obviously. They think they're special. Rachel Smith would be, nobody's talking yet, you guys. There's nobody talking, so that's why you're not hearing anything yet. Rachel Smith is the court reporter. Rob Wood, you guys know, is the DA. Lindsay Blake is the special prosecutor. The green bar is on the judge, but he is not speaking. I see them just trying to come in now. I hear them on the Zoom trying to come in, so they will be added to the Zoom momentarily. Oh, thank you, Beverly. Oh, you should see me when I've had a glass of wine, Beverly. You never know what's going to come out of my mouth. Come on, Twinkle Toes, let's go. He reminds me of Fred Flintstone, so I call him either Dumbbell or Twinkle Toes. Come on. Get your crap together. Oh, Rosie, apparently I get hilarious when I'm drinking wine. Then I get a bad headache and want to just go to bed. Well, at least Lindsay Blake isn't chomping on something now.
Madam Clerk, do you have a way to message Mr. Pryor about exiting the breakout room?
I do, Your Honor, and I can just close the room and it'll stop in about a minute, so.
Okay, why don't you do that?
Okay, so can you guys hear now? The judge was speaking. Can you hear it? Okay. Those dumb balls are stuck. There they are. Hey, Twinkle Toes. Still see that? You got that stupid look on your face? Like, oh, what's going on?
Okay, we'll be back on the record here. We took up some evidentiary issues outside of the presence of the live recording here due to the potentially inflammatory nature of the proposed exhibits that were being offered. Court went through motion regarding admission of certain exhibits and made a ruling on that. I will note on the record that we did have the court reporter there for those proceedings, and there will be a record of those proceedings, which were taken out not in the presence of the live recording. With that, then, the ruling the court made was as it relates to proposed exhibits that have been offered by the defense in support of the motion. Those are contained in a electronic folder that has 10 separate subfolders. The court admitted subfolders 1 through 8, with the exception of a photograph in subfolder 3 that was not admitted. On the other subfolders, those haven't been proffered yet. And on number 10, that previously was the survey, the insight survey that the court ruled was inadmissible. So before the court then, which has been admitted, are the exhibits contained in those subfolders 1 through 8, with the exceptions I just mentioned. And the court made that ruling based on a self-authenticating analysis under Rule 902, subsection 6, and Idaho Rule of Evidence 101, F3. Also considering case law, the court considered including the Chiampi versus City of Palo Alto case 790 F supplement 1077, and in conjunction with the Idaho rules, determined self-authentication for those published items. So
Betty
those
Smith,
items will be
Lindsay,
considered by the court at this time as admitted. And again, any reference to those, if they're inflammatory in nature, Mr. Pryor, I'd require you to just refer to those in generalized terms, and I'll locate them on those drives. So that was the ruling on our evidentiary issue. With that in mind, then, Mr. Pryor, this is still your motion and your time to argue the motion. Do you have another witness you're going to call?
Judge, I have no further witnesses in light of the court's ruling admitting those 8 folders with the information that's contained within them. At this point, what I have left to do is make argument. So if the court wants to allow Mr. Wood to call his witnesses, then at the conclusion, if the court wants to proceed that way, I'll make my argument and obviously Mr. Wood's argument and my rebuttal, and we could wrap this hearing up if that's the way the court wants to proceed.
Mr. Wood, do you have witnesses you intend to call in objection?
Your Honor, we do have 2 witnesses. My suggestion would be that where it's noon, that we break for lunch and reconvene whenever the court says we should, and at which point our witnesses are ready and ready to go. But I do think now would be a good time to break for lunch.
Okay, I think that's a fair request at this point in the hearing and the proceedings. So we will break for lunch from 12 to 1. And I'd ask counsel to be ready to start up again at 1 o'clock, and we'll have your first witness then, Mr. Wood.
Thank you.
Thank you. We'll be in recess then for an hour.
So who are our 2 witnesses?
yes, they just got back, but you got to remember they were in a breakout room and they heard some motions over there. So they weren't, although we weren't seeing any of that was going on in all those arguments. It was still going on behind the scenes. So they didn't get the break that we got. So now they are going on an hour break for lunch. So I'm going to keep this open. If you guys want to chit chat still in here, I am going to take that hour to get a few things done here that I need to be done. I will leave this open. So when it does start back up, we will be right back on cue. I'm going to put a banner up saying that we are on break for an hour. It's almost 2 o'clock here, so it would be 3. We will be on break until 3 p.m. Eastern, which I guess would be 1 p.m. their time. So I'm going to leave this open, you guys. I'm going to mute myself. And yeah, like Chad needs another meal. He needs a happy meal because he doesn't look too happy. We're going to take a break. Oh, I'm sorry, Rosie. Poor Rosie's at 5 a.m. Wednesday morning. Rosie, it's all going to be here, so it will be up on my YouTube channel. If you do need to go and go doze and go have a little nappies for an hour, but if not, it will be here for you guys to watch later. So it's in an hour from now. So an hour from now would be 3 p.m. Eastern. So whatever it is your time, Anne, it's an hour from now. And I will scroll that across the bottom. Okay, so an hour from now, you guys, I will see you right back here. I'm going to leave this open in case you guys do want to chit-chat a little bit. Feel free. And I will see you guys back here in about, I'll be back in about 45 minutes. Okay, hello all. I'm back. Is everybody coming back in now? Okay, so a little bit more information that has come out for everybody that's here anyway. Brian Laundrie's sister gave an interview this morning to Good Morning America. And in that, she stated a few more things other than what we'd already heard. She says that if she knew where Brian was, that she would turn him in. So she is asking him to turn himself in. She's also asking her parents that if they are involved in any way, or if they've helped him or know what's going on with him, anything, that they need to come forward. Also, she hopes that he's alive so everybody can get answers, including herself. And she did talk a little bit about when she was there at the campsite on the 6th. She said that they were there from about 1 till 8 p.m. I guess there was they went to the water type thing. Brian took one of her children down to near the water. They had dinner. They had a campfire that night and cooked some s'mores. And she said that she didn't notice anything out of the ordinary, like nothing that would have given her a clue as to what was happening or what had happened. The parents didn't say nothing. Brian didn't say nothing. Nothing was said about it. So I do believe her, you guys. And like I said, she has asked even her parents that if they do know anything, that they need to come forward. And I do believe that the parents know that Cassie would turn him in, and that's probably why they are not speaking with her. So I'm going to, right now, I'm going to post that link to that interview on my channel. I'm going to also post it on Facebook, and I think I've already posted it on my Twitter. So oh my gosh, it's saying page is not available. Why is it saying that? Okay, they're coming back, you guys. I hear people in the courtroom. I'll have to put the link in later. I don't think I'm going to have time to find it again. Yeah, I'm going to have to find it. It sounds like they are coming back into the courtroom, you guys. Okay, there's a lot of people still here. Perfect. I just heard stuff in the courtroom on the Zoom. Okay. Oh, that's okay, Cindy. I've got to find it later anyway. I will be able to copy it from here because I'm back on the StreamYards. I'm not on the YouTube, so I wouldn't be able to copy it or anything anyway. So, and Trimus says I started back at the beginning. I'm playing Willow at 1.75 speed, trying to catch up. That's funny. Yeah, I do have the link already. I believe it's over on my Twitter or whatever, so I can just grab it from there when need be. So we're just waiting for everybody to come back in the courtroom. It should be starting again in about 5 minutes. Let me just go over and okay. Sorry guys, I'm just getting a few things out here. So when you have multiple platforms, it's time consuming. Okay, so I got that back out. Okay. Alrighty. So we are back. I just heard voices in the courtroom come through on the Zoom. So I'm just listening, you guys. It should be starting momentarily. Yeah, the clicking is hard at work. Yeah, I've got 6, 7 different windows open here that I'm going back and forth between and trying not to lose my connection here to the courtroom in all of that, because I have been known to, oops, click the wrong button and lose everything. Yep, it should be starting any minute. Like I said, I just heard them on the Zoom in the courtroom. So they are getting ready to get this back up and running. So that was quite the statement, I guess, that Cassie did come out and say again. It seems like she's doing several interviews now with different stations. Good Morning America. If you're just joining, I will repeat it again. She states that she would like her brother to turn himself in. But she did, with that being said, she said that if she knew where she was, she would turn him in, and asking her parents also that anything that they know of this, whether they were involved or not, anything that they know regarding Brian, to come forward with that information. She hopes that Brian is still alive so everybody can get answers. And she also, spoke a little bit about when she was at the campsite on the 6th, that it was just a normal day. They went there, they played around, splish splashed. I guess the kids splish splashed with their uncle in the water. They had dinner. They had a campfire with s'mores and that afterwards. And then they left. She didn't see anything out of the ordinary that would make her think that anything like this had happened. Apparently there was, I'm just reading my notes here, guys. She says that there was nothing said out of the ordinary, that nothing regarding what has now come to light, nothing like that had been talked about at all during the time that she was at this campsite. And that apparently it's the laundry lawyers that have told the laundry parents not to communicate with Cassie. And I'm assuming by the sounds of things that the reason that they don't want her communicating and they don't want the parents communicating, these lawyers, is because they feel Cassie is going to give up some information that she shouldn't. Okay, so it looks like the court is coming back in session, you guys. I'm going to go full screen. Judge Boyce seems to be the only one here right now. Oh, there's Rob Wood. Sorry, you guys, I'm just jumping around here to see. If there's anything else that I can give you before this starts. I'm checking all my different feeds here. So please forgive me for a minute.
All right, I think we've got everyone here. Madam Reporter, are you ready?
Okay, so they're back,
Yes,
you
Your Honor.
guys. Can everybody hear?
Okay, we'll go back on the record after the lunch break on this matter. This is the time for a change of venue motion. Case CR 2221-1623, State versus Chad Daybell. Council's present and appearing. At the time of the lunch break, we concluded with Mr. Pryor's presentation of evidence. And at this point, Mr. Wood, I understood the state had witnesses to call. Is that correct?
Yes, Your Honor, I'm not seeing them in this room. I don't know if they've been accepted yet.
Okay, who's your first witness you're intending to call?
Len Humphreys.
All right, let's see if he's there.
Need to be logged in right now or wait?
It's like he's having an issue getting connected. Do you know where he's appearing from, Mr. Wood?
I believe his office, but I'm not sure, Your Honor.
Okay. I just wondered if he was there.
He's, oh, there he is.
Good afternoon, Sheriff Humphreys. Can you hear me okay?
Yes, Judge, I can.
Okay, thank you. Wanted to make sure you were properly connected. So, Mr. Wood, you may go ahead and call your first witness then.
And the state calls Sheriff Lynn Humphreys.
All right, Mr. Humphreys, if you, or Sheriff Humphreys, if you'd please raise your right hand, I'll have the clerk administer the oath.
You solemnly swear or affirm the testimony you will give in the pending cause will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you. You can lower your hand, and counsel, you can inquire.
Thank you. Can you state your name for the record?
My name is Len Humphreys,
Can you spell your last name for the record?
Humphies.
All right, and you said sheriff. Can you give us a little more background on that?
I am the Fremont County Sheriff. This is my 13th year as sheriff here in Fremont County.
Okay. So 13 years as sheriff in Fremont County. How long have you been involved in law enforcement?
Went to work here full-time in 1988.
Okay. Today, what I need to ask you about, Sheriff, I want to talk about some of your responsibilities as it relates to the district court. Are you responsible for any actions connected to the district court proceedings and jury trials in your role as sheriff?
Yes, we're responsible for the security of the courts. We provide the bailiff services, security for the courthouse. We run the entries where people go through magnetometers to make sure that there's no weapons. We're responsible for making sure that defendants are transported to and from court in a safe manner. We are also responsible for making sure the juries are safe, and witnesses that they are taken care of. We provide all of those services through the sheriff's office.
And Judge, in objection to where we may be going, I am concerned that the testimony is going to be focusing more on Mr. Wood's motion to impanel a jury than it is to address any concerns he may have about the change of venue. So I guess in the form of an objection, I'm deeply concerned that we're addressing the other issue and not the issue of how this affects a change of venue.
Well, there's been no question relating to that at this point, so that's premature, but I'll keep that in mind.
Thank you. And Your Honor, I would just note the state hasn't filed a motion to impanel a jury. So Sheriff Humphreys, thank you for going over that. Are you also, you said you're responsible for the defendant's security. Are you responsible for housing the defendants?
Yes, we are.
Okay. And are you familiar with the case of the cases of Chad Daybell and Lori Vallow?
Yes, I am.
And are those defendants under your care and custody?
Chad Daybell in my jail here in Fremont County. Lori is in the Madison County Jail, who contracts with us to house our female inmates.
Okay, thank you. Now, the responsibility to cover court proceedings on crimes occurring in Madison County, does that responsibility exist wherever the case itself goes to trial?
I'm not sure I understand your question.
Okay, I'll rephrase it. I think I said Madison County, I meant Fremont County. So I apologize. If a case is a Fremont County case and a change of venue takes place and if that a case is heard elsewhere, do you still maintain the same responsibilities that you would maintain as if it were in Fremont County?
I believe that is the case, either by providing the staff to take care of it or contracting with the host county, wherever that may be.
Okay. Now, do you have a detectives division?
I'm sorry, once more?
Does the Fremont County Sheriff's Office have a detectives division?
Yes, I have 3.
Okay. And are you aware if they've been involved in the case involving Chad Daybell and Lori Vallow?
Yes, they have been involved.
Okay. I want to talk to you about kind of the monetary and manpower costs that arise if they have to travel outside of Fremont County.
Judge, I'm going to object at this point. We're going into the motion of sequestering a jury and the costs that are associated with that. Mr. Wood can shake his head all he wants, but this is a backdoor way to address issues that I'm not prepared to address in terms of fixed costs. If the court's going to allow Mr. Wood to go into this avenue, then I want to be able to question this witness about all of the costs that are associated with bringing a jury from another county or otherwise, because that's exactly what he's trying to do here.
Well, it's overruled at this point. We'll see where the testimony goes on the issue. Of course, the matter before the court today is whether or not venue should be changed, meaning transfer the location of the trial, and I find this to be relevant testimony, so that's overruled. You can continue, Mr. Wood.
Thank you. If your detectives are subpoenaed to testify outside of your county, what are some of the costs that are associated with complying with that subpoena?
Judge, again, I'm going to renew my objection. This goes to the sequestering a jury and cost as it relates to that.
All right.
Your Honor, I'm not talking about
Third
sequestering
time,
a jury.
counsel. Yeah, I'm overruling the objection for a third time, Mr. Pryor. This is just in question as it relates to possible change of venue. So continue, Mr. Wood.
Thank you. Sheriff, do you recall the question, or do I need to ask it again?
As I recall, the question was the cost involved when deputies are subpoenaed outside of the county. Those costs would be travel costs, of course, per diem, for meals, lodging, overtime costs, possibly. The additional cost of having the deputies outside of the county means that the calls and work that they would normally be doing, I would have to have covered by other officers or have that work delayed until somebody was clear and able to take care of it.
Okay, so it's your testimony that if you had multiple detectives subpoenaed outside your county for a trial, and especially a lengthy trial, could that cause manpower issues for Fremont County detectives or Fremont County Sheriff's Office?
Yes, it would.
Okay. And is it fair to say that those detectives have more cases than the Vallow Daybell case?
Yes, that is fair.
Yeah. Now, at this time, can you put a dollar amount on how much it will cost Fremont County if your detectives are subpoenaed to testify outside of Fremont County?
Excuse me, Your Honor, I'm getting terrible feedback. I can't.
I'm hearing it too.
Yeah, so am I. I'm not sure where that would be coming from. Maybe Sheriff Humphrey's microphone. I'm not sure.
I believe this is from Mr. Ward.
Yeah, it seems to be happening when I'm speaking part of the time.
Okay, hopefully we can figure out where that's coming from. I wasn't doing it before lunch, so I'm not sure why it would be doing it now.
Okay. Sheriff, do you need me to ask that question again?
Yes, please.
The question was, at this time, can you put a dollar amount on how much it will cost Fremont County if your detectives have to travel outside of Fremont County for if they're subpoenaed to testify at a trial?
The there's no way that I could estimate what those costs would be without knowing where the trial might be held or how long the trial might last.
Okay. We've talked about your detectives being subpoenaed and what that would do to the detectives department. What are some other responsibilities you may have to provide in another county if a trial is moved?
I anticipate that the same costs would apply as far as providing security, providing transportation, providing housing for employees, as well as jurors, things like that.
Okay. Is it your opinion that trying these cases in Fremont County would be more economical for the Fremont County Sheriff's Department than having it tried in another county?
Judge, I'm going to object at this point. There hasn't been sufficient foundation to suggest. In fact, this witness said that without sitting down and knowing exactly where it would go, he can't make a determination of what the cost would be. So to allow him to speculate would be completely improper. And at this point, allowing this sheriff to make an assessment without knowing where the county that this thing will be moved to, or the additional costs that might be incurred. And again, I'll renew my objection that this actually goes to Mr. Wood's sequestration of a jury in another county. So if Mr. Humphreys wants to come back and talk then, great. But at this point, allowing him to offer an opinion is highly improper.
Mr. Wood?
Your Honor, I think that the sheriff, first, we're not talking about sequestering a jury right now. That's completely separate than a change of venue and the costs that might be associated with it. In terms of what he can testify to, we've already established that, yes, he cannot give an exact dollar amount. However, I do think as the sheriff, he is qualified to testify about the extra expenses of providing these services outside of his own county.
And Judge, actually, this sheriff mentioned the cost of housing a jury. So he brought it up in his case in chief testimony. So again, there's been no specifics, and basically you're going to elicit an opinion from a guy whose qualifications are he's the sheriff without any factual basis for what that opinion is based on.
All right, well, I can consider the testimony for the weight of what it's worth based on the foundation, but I do find that under both Criminal Rule 21 and Title 19, Chapter 18, which discusses removal of an action before trial, that cost can be a consideration, so I do find it's relevant, and I'll overrule the objection, so you can answer, Sheriff Humphreys.
Would you repeat the question, please?
Yes, is it your opinion that trying the Chad Daybell case in Fremont County would be more economical for the sheriff's department than having it tried in another county?
I do believe it would be more economical to be tried here, yes.
And why is that?
We don't have the travel costs involved. We don't have the issues of providing services in a trial outside of the county, and also maintaining services that go on while this trial is going, the other services, the other duties that need to be carried out on a day-to-day basis.
Okay. And so just one last question. Do your duties in Fremont County cease if you have to provide those services in another county as well?
They do not cease. Those services still need to be provided here.
Okay. That's all the state has at this time, Your Honor.
All right, thank you, Mr. Pryor. Cross-examination.
And Sheriff Humphreys, could you tell me how many employees you have within the sheriff department who are deputized?
Deputized, I have approximately 21 officers right now.
How many of them are involved in the Daybell case?
At least 3 that have been involved in the investigation.
So obviously you understand and would agree with me that you obviously don't want those 3 deputies who are involved in the Daybell case to perform the functions within the department. Would that be fair? In regards to security, in regards to transporting Mr. Daybell or otherwise, right?
So the two of those are detectives, and the third is my patrol lieutenant, who was a prior detective and was very involved with this case.
All right, so the question, and if you would answer it, is simply that we don't want those 3 deputies involved in the day-to-day process of such as transporting witnesses, obviously guarding Mr. Daybell, because the potential for some sort of conflict arises at that point, right?
Yes, that's correct.
So we're down to approximately 17 or 18 deputies, correct?
Yes.
And how many deputies does it require you to maintain the jail on a daily basis?
I have 2 deputies on duty at all times in the jail.
Okay, and for how many in a given shift of 24 hours?
That would be 4 and 5 with the supervisor.
And it requires all 17 to provide appropriate supervision, or are you short manned within the sheriff's department in the jail?
No, we are fully staffed at this time.
Okay, so the question then would be, obviously, if anybody has any connection or any sort of link to the Daybell case, you obviously want to exclude them as part of the as part of participating in the day-to-day activities of dealing with jurors, dealing with witnesses, and that sort of thing, correct?
Yes.
And it would be highly inappropriate for someone who has some sort of involvement, even a minimal amount of involvement, to allow themselves to inject themselves in the case, right?
Correct.
Objection goes beyond the scope.
Well, Judge, he's talking, thank you. So, Sheriff Humphreys, I do have a question for you. I'm looking at a June 11th of 2020 posting on your Facebook account. And on the Facebook account, it shows you retweeting pictures of a fence, some posters of J.J. and Tylee. It looks like some pictures of a vigil, and there's some
Objection beyond the scope of the direct.
Judge, it goes to whether or not there's involvement by a police officer involved in this case. I have information that this officer is using his private Facebook account to make postings about this case, and further, that Mr. Wood is giving the thumbs up on these accounts.
So, objection relevant.
I think it's relevant.
Okay, the issue, underlying issue on change of venue is potential pretrial publicity or bias or prejudice that's come about to potential jurors because of that. And so as it goes to the underlying issue, I will allow for the line of questioning, but Mr. Pryor, I admonish you as previously, if it gets into anything that's inflammatory, I want to take that up outside of the live stream.
Okay, and I'm going to refrain from getting into terrible specifics about some of the things that you post. But Sheriff Humphreys, quite frankly, how many times on your personal Facebook account did you post information or pictures about Chad Daybell or Lori Vallow?
I don't know what you're looking at.
I don't care what I'm looking at. I'm asking you how many times you posted these things on your Facebook account.
Objection
How many?
argumentative.
That is argumentative, Mr. Pryor. Allow an opportunity to respond before you just jump in like that. So Sheriff Humphreys, if you'd respond and further elicit the question of when you said you don't know what he's talking about, what do you mean by that?
I don't recall having posted or forwarded anything showing that on my Facebook account.
Okay, so you have never posted anything on a Facebook account that shows Len Humphreys?
Objection, he's
In regards to
misstating
the,
the
in
testimony.
regards to the, and if I could finish, Mr. Wood, in regards to the Daybell and Vallow case, is that your testimony, Sheriff?
I don't,
Objection asked and answered.
He hasn't
Overruled.
answered.
Go ahead and answer, Sheriff.
I don't recall having posted a forward that you have described.
Okay. So do you have access to your Facebook account, and have you deleted anything since June 11th of 2020? Because I'm looking at a Facebook posting with your name on it, dated June 11th of 2020, and it's your picture, and it's obvious that there are images on there that are regarding the Daybell case. Do you
And I'm gonna,
if I could finish, Mr. Wood, are you
I'll let you
disputing
finish.
that took place?
Your Honor, I'm going to object to the form of the question. I'm going to ask that we go into a breakout room, that Mr. Humphreys be shown this exhibit rather than be browbeaten about something that he doesn't know what Mr. Pryor's talking about.
Do you have a copy of the posting you're concerned about, Mr. Pryor?
I have a copy of several postings, Judge, and if you want to go into a breakout room and have a shared screen, we can discuss all of them.
Well, I think that is appropriate for him to be able to
Okay.
view those versus testifying about them. So
Okay.
in order to avoid inflammatory material being broadcast in this proceeding, we still will be on the record. The court will consider sealing portions of the record if necessary. I'll conduct the further inquiry of the witness in regards to these Facebook posts in the breakout session, which will be still on the record with the court reporter. So Madam Clerk, if you'd set up the breakout room, we'll do that.
So we're going into a breakout room again. And Rob Wood is still sitting there. He's like, he's gonna blow a blood vessel. Is Rob Wood not invited to the breakout room? Oh, there he goes. Bye-bye. So we're in a breakout session yet again. So what do you guys think so far? Like, I swear to God, I'm waiting for John Pryor's head to almost explode there. It's like the blood vessels are coming out, and it's like, ooh. When he says Pryor psycho, he's just very passionate about what he believes in and what he's bringing forth. I don't think he needs to get as worked up as he does, but that's, I know where he's coming from because I can do the same thing. So, especially when I feel something is, if I'm passionate about something or something is affecting me terribly, I tend to get worked up like that too. So I kind of know where he's coming from, but I don't know. He's almost ready to blow a blood vessel. Well, that's what he was hired to do, right? Texas woman says Chad Daybell's lawyer on the attack. But that's what he's paid to do, right? So, yeah, there's a lot of aggression. That's what that... to me, it's not just the passion. I think there's a lot of aggression there, too. So, Miss Tina says probably deleting it now. Like, that's the thing about social media, you guys. It never goes away. People screenshot it, people download it, people, you know, it's always there. Once you put something out, it's there. Oh, this is just like motions hearings. Can you imagine come trial? Bruce says, if this is true, above this not look good on Chief doing stuff not, yeah. If that's what he was doing, it's not a good look. And that's having worked for defense attorneys and in the criminal law, when you've got witnesses for the prosecution are your enemy as a defense attorney. You got to find any little thing that you can on these witnesses to try and make them less believable. Any little thing that you can find to roll things a little bit in your favor. And that's what John Pryor's doing. He's a pebble. Hey, he's going to give himself a heart attack or blood. bust a blood vessel or something. There's Nana. Hello, Nana. I do believe that this trial is going to go for at least a couple months. But I mean, in a way, John Pryor does have a point. If the sheriff was doing this stuff, then again, the DA can come back with, hey, who's to say that is actually his account? We know with a lot of the drama we've been seeing on even YouTube, people are creating spoof accounts and sock accounts and everything using other people's information. So is that something that could have happened? We don't know, right? There's Hobby Cat. Welcome back. Yeah, and it does. It could affect, I'm not going to say it's going to ruin it, but it could affect his credibility. Well, Miss Tina, it's not just that. It's he has recopied things onto his personal Facebook page from the sheriff the sheriff page to his personal page, and things were going on there that shouldn't have been going on. I'm sure Mark Means is following this. He's not involved in this aspect of the case because this is regarding just Chad Daybell right now, because Lori's stuff has all been put on hold while they bring her back to sanity or whatever they're trying to do with her. And I agree. Chartreuse Seeker says, I think John Pryor interrupts loudly on purpose. Yes. It's an intimidation factor, and that's what he's trying to do. And if you've seen the sheriff's face when John Pryor, watch the sheriff's face when they come back. And when John Pryor is raising his voice to the sheriff, like the sheriff's not used to that. The sheriff is used to having people listen to him. So for John Pryor to get up and personal like that and loud, it kind of sets him back. Watch his facial expressions. They tell you a lot. Sorry, you guys. Yeah, it's his job. He's been hired to defend Chad Daybell in the best way that he can, and he's going to pull out all the stops. And if that means attacking the local sheriff, well, that's what he's going to do. I mean, what's the worst that can happen? Overruled, right? So anything that he can throw out there, he is going to do because he's got nothing to lose by doing so. Everything to gain, nothing to lose, except for an overrule. Jury's LC says, I don't know if the jury is going to like Chad's lawyer. He's not everybody's cup of tea, but you never know. Yeah, I would rather listen to John Pryor than Mark Means too. Mark Means, that's just a circus. He's way out of his league on this. So I guess we wait. They're going to fight backstage. Have a little boxing session there, and hopefully everybody comes back all in one piece with all their veins still in their body. Katie Marie, yes, I am going to be doing some updated reads as soon as I am back to 100%. I will not do any readings until I'm 100%, because I would just be off. I'm feeling a lot better today. It's going into my chest now too, so there's a factor there with trying to talk and not be able to, when I'm recording, I can't mute myself. So to hack and cough and everything through a read is not good. And it sets me off. If I'm not at 100%, I won't do a read. Yeah. Cindy says Willow may need to do a vacation take 2. Yeah, I've been pretty sick the last couple of days. Today I'm not so bad, but I tried to take a vacay last week to give myself a break. To rejuvenate and to revive myself here and get all my scruples and everything back. And there was just too much happening that had to be covered and needed to be spoken about, so that week vacay from YouTube just didn't happen. I did slow down a lot, but I didn't take a vacay like I should have. And then I ended up sick as a dog nearing the end of that so-called vacay that never happened. And I seriously thought that I had caught COVID because I couldn't smell, I couldn't taste. But my smell and taste is now back now that my sinuses have become unblocked. But for a couple of days there, I was kind of worried. And then I got my results back saying that no, I did not have COVID. So, and being that I already have sinus problems since I was younger and asthma, when I get a common cold or something like that, it's tenfold. So I'll be okay. Oh, thank you, Chartreuse Seeker. Yeah, it's been like fall time is bad for me for the allergies and everything else to begin with. Okay, so they're back, you guys. So I'm going to mute myself. Let's see what's going on here. And hopefully everybody comes back with their heads still on their shoulders. Looking so far so good. Where's Mr. Wood? Uh-oh. Somebody blew a vessel.
Your Honor, I just received a message from Mr. Wood that he's tried re-entering, and it sounds like maybe he wasn't able to get back in.
Okay, we'll give him a few minutes and hopefully when he logs back in, it'll
It
resolve.
looks like he's coming in now.
Okay, thank you.
Hopefully his audio is fixed, because there's a lot of feedback from Wood's audio. Okay, so I'm going to mute myself again, you guys. Let's see what happens now.
All right, hopefully the feedback issue's resolved. You just want to say something, Mr. Wood, to test that out?
Checking. I'm not hearing any feedback now.
Yeah, I think it's better. So thanks for doing that. All right, at this point, Mr. Pryor, then you can continue your cross-examination of Sheriff Humphreys.
And Sheriff Humphreys, after we had an opportunity to go in the break room and you had a look at the Facebook posting, you will acknowledge that on your personal Facebook account on June 11th of 2020, you posted images and a story about the Chad Daybell, Lori Vallow case. Is that true?
I did on that date, yes.
Okay. Do you have any recollection, sir, of any other dates that you may have put on your personal Facebook account, images or stories about Chad Daybell and Lori Vallow?
I do not have any recollection of any others.
Is it possible there are others out there?
I don't believe so. I didn't remember having done this one, but I recognize it when I.
And this wasn't on the sheriff's website that this was posted on Facebook, was it?
That's correct.
This was on your personal website, correct? A personal Facebook account, correct?
That's correct.
How many followers do you have, sir?
I have no idea.
Okay, thousands?
I don't think so.
Okay, but you would agree with me as the sheriff of Fremont County, you have probably a significant following within the confines of Fremont County. Would you not agree with that?
Objection calls for speculation.
It calls for him to answer a question about his following in Fremont County.
The objection's overruled. And counsel, for both of you, if you make an objection, give me an opportunity to respond first. I may make a ruling without jumping in to counter that, or I may ask for additional input. So with that in mind, the objection's overruled. You can answer, Sheriff Humphreys.
I don't know how many people follow my Facebook page.
Okay. Well, you agree with me that you know how Facebook works. You send an image out to the people who follow you. And not only does it go to the people that follow you, it goes to the people that are on their accounts as well. Does it not?
I couldn't answer as to how Facebook is that way.
Are you aware that you and Mr. Wood are friends on Facebook?
I was not aware of that, no.
Okay. Do you dispute that you and Mr. Wood are friends on Facebook?
I don't know who all is listed as friends on my Facebook page. I don't spend very much time on there.
But you would agree with me that a sheriff who's involved in one of the biggest cases in the country on his personal Facebook account starts posting images as it relates to an investigation in his county. At the least, you would call that questionable conduct, wouldn't you, sir?
Objection calls for speculation.
Overruled on those grounds.
You would call that questionable conduct, wouldn't you, sir?
Objection argumentative.
Judge, you already ruled on it.
Well, that's sustained. It is argumentative.
Okay.
The questionable conduct also does not provide any guidance for the court.
Okay. So is it your position, Sheriff Humphreys, that since you did do some postings and have commented on the Daybell case on your personal account, that you should be excluded in participating in decisions regarding Chad Daybell and his trial?
I make very few decisions regarding his trial.
Well, you posted something on your personal Facebook account about the case, sir, and you acknowledge that you did it. And at this point, you're telling me there's nothing else out there. That's yet to be seen. But at this point, don't you find it inappropriate that a sheriff investigating a criminal case of some notoriety is putting personal postings about the case on his Facebook to some of his friends within Fremont County? You don't see that as a problem, sir?
Objection relevance beyond the scope improper arguments. Argumentative.
Judge, it's actually proper. It goes to bias of this sheriff. He's posting things on his Facebook account and he's sitting there and saying, well, go ahead, Judge, I'm sorry.
Well, law enforcement typically can be biased when they're investigating cases. That's not grounds for this line of questioning. He's a law enforcement officer. It's a personal account. It wasn't posted on the sheriff's official website. The impact that may have on the issue of change of venue is all that the court's concerned about at this point. And I do find the line of questioning improper at this point, and I'm sustaining that objection by Mr. Wood. If you want to get to the relevance of how many people this may have affected in a potential jury pool, that's what the court's concerned with today, Mr. Pryor.
Right. And that's where I'm going, Judge, is that in Fremont County, you would agree with me, Officer Sheriff Humphreys, that Fremont County is a relatively rural county. Would you agree with that?
That's correct.
And you would agree with me that there's been a significant, in fact, a great amount of press coverage as it relates to this case, correct?
There has been.
And you would agree with me that the press coverage in Fremont County alone has been saturated with a variety of photos, videos, stories from East Idaho News and others, correct?
Numerous outlets.
Right. And you would agree in this small rural community with that amount of significant press coverage and a sheriff who's the county sheriff in that, you don't think that you posting things about the Vallow Daybell case has an impact on some of the citizens of Fremont County, Sheriff?
I don't know what impact would be I do not know what impact that would have.
Okay, but you would agree there'd be an impact, right?
There could be.
Okay, and you would agree that it was probably a bad choice to post things about Chad Daybell and Lori Vallow on your Facebook account. You'd agree with that, right?
I do agree with that.
Okay, so in other words, you were at least, and Sheriff, I don't want to berate you and beat you up, but it's not the point here, but what I'm concerned about is that Mr. Vallow or Ms. Vallow and Mr. Daybell get a fair opportunity. And you would agree with me that the amount of publicity has been significant. And as the sheriff of this county, contributing to that, however it's gauged, only adds to the media attention and the postings that are increasing the amount of attention brought to this case in Fremont County. You'd agree with that, right?
Objection calls for speculation.
Overruled.
You
If
would
you
agree
can,
with that, Sheriff, correct?
I should not have done it. Yeah, correct.
Okay. And in all likelihood, your posting could have been a factor in at least swaying some people in Fremont County. We don't know how significant. It could be greatly significant or it could be de minimis. You'd agree with that, right?
Objection calls for speculation.
that's sustained.
Okay. But obviously there was an impact by your actions by putting that on your Facebook account, right?
Objection calls for speculation.
Well, it's asked and answered, so move on to another question, Mr. Pryor.
No, I think that's it, Judge. I'm fine. Thank you.
No more questions for the
No
witness
more
then?
questions, Judge. Thank you.
All right, thank you. That'll conclude the cross-examination. Any redirect, Mr. Wood?
Just one moment, Your Honor. Just one. Sheriff Humphreys, in the post that you saw, did you mention Lori Daybell or Chad Daybell?
I forwarded a post that I saw that,
Well, just answer the question. Did you use the names Lori Daybell or Chad Daybell?
no.
Okay, that's all I have, Your Honor.
All right. And with that, that'll conclude the testimony of Sheriff Humphreys. Thanks for your appearance today. You can be excused. And Mr. Wood, if you have another witness, you can call them at this time.
Your Honor, the state calls Shane Turman.
The post that I saw that,
Is his last name Turner or Thurman?
Turman.
And how's that
I'll have him
spelled?
spell it.
Okay,
That's showing up as Turner. I'm not sure why.
okay. So it's Turman.
Yes.
All right, Mr. Turman, if you can unmute, please, and if you can get a video signal. There we go. If you would unmute your microphone, please.
Is that?
Okay, I do hear you. Not real loud. I think you might want to talk into your microphone for the questioning. Let me first ask you, is that the correct spelling of your name as listed on the screen there?
Yes. That's correct.
All right, thank you, Officer Turman. At this point then, Mr. Wood, if you'd like to call that witness.
Thank you, Mr. Turman. Can you state your name and
He needs
spell
to
it
be
for the
placed,
record?
sorry, he needs to be placed under oath as well before. So, Officer Turman, if you'd please raise your right hand, I'll have Madam Clerk place you under oath.
You solemnly swear or affirm the testimony you will give in the pending cause will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay, thank you. You can inquire, Mr. Wood.
Thank you. Can you state your name, last name?
It's Shane Turman. Spelling of my last name is Turman.
Thank you. And what's your title?
I'm the Chief of Police for the city of Rexburg in the state of Idaho.
Okay. How long have you been the chief of the Rexburg Police?
10 years, and this December will be 11 years.
Okay. And how long have you worked for the Rexburg Police Department?
Approximately 33 years.
Okay. Have you ever served as a detective?
Yes, I have.
Okay. Are you familiar with the case regarding Lori Vallow Daybell and Chad Daybell?
Yes.
How have you been involved in that case?
Well, as the chief of police, I've known that it's been going on. My detectives that work here have been some of the key detectives in this case. And so as the chief of police, I've had to make funds available and see to their needs and staffing so that they could perform their duties in this investigation.
Okay. And so have you worked with your detectives and their involvement in this case?
Just getting updates from them. But I
Okay.
have investigation myself.
Okay, so you haven't investigated it, but what has your detectives division's involvement been in this case?
They've been involved in this case from basically day one. I believe it was starting November 1st of 2019 when we received phone calls from a detective in Gilbert, Arizona, asking us to look for a Jeep they believed that was involved in a possible crime down there.
Okay. And let me go back for just a second. How many detectives do you have in your detectives division?
I have 6.
Okay. And is that the current number?
That is the current number.
Okay. Have you had any detectives that have worked on this case that have since retired?
Yes, I've had one detective that I've had 2 detectives retire since this case started, but one of them was really the only one that was working on it out of those 2.
Okay. And as the chief, are you aware that the detectives who worked on that case could be subpoenaed as witnesses to testify at trial?
Yes, I'm aware of that.
Okay. And I just want to ask you a few questions about if a change of venue in this case is granted and the trial is moved, what kind of cost does the Rexburg Police Department incur as a result of that?
Well, for instance, if we go to the city has a scale for per diem, and so we would have to pay per diem for each one of those detectives, along with depending on how far out it was. If it was a place where we'd have to get them a hotel room, we'd have to get each one of them a room. And for the city, roughly, it's about $71 a day per diem, going off of someplace like Boise, Ada County, most places.
Does that per diem amount change depending on where the location is?
It can, but the 71 is pretty close to most of the places in the state of Idaho.
Okay. So you mentioned per diem costs, you mentioned hotel costs. Are you responsible for their travel costs?
Yes. So we would pay for a hotel room for each one of those detectives plus their per diem.
Okay. Chief, of the detectives you have now, do you know how many of them have been significantly involved in the Vallow Daybell case?
Yes, I have 5 out of my 6 detectives that have been significantly involved.
Okay. And in the event they were subpoenaed for trial, and we don't know how long the trial would last, but I think we can assume it would last several weeks. What effect would that have on your detectives division in Rexburg?
Well, you know, the number one thing as the chief I'm responsible for is the protection of our citizens here. And, you know, as you know, we have a college with 22,000 students. And each one of those detectives is carrying a caseload, dealing with all kinds of different crimes. It would really hinder us because I'd only have one detective that would be available to handle all of that. Our detectives are trained, highly trained, in fact, in things that a lot of our patrol officers aren't trained in. And so, you know, for instance, interviewing and interrogation and things like that. And, you know, right now, a lot of our cases that our detectives are dealing with deal with child abuse, sexual assault type cases. There's some major cases as well.
I'm going to object at this point. We're getting a little off the mark in terms of the dissertation.
Well, it's objections overruled, but I would ask you to keep the questioning in line with the scope of this hearing, Mr. Wood.
Okay. So Chief, just to make sure we understood what you were saying, is it your testimony that it would cause a hardship for the detectives department if they were subpoenaed for a significant amount of time out of their jurisdiction?
Absolutely.
Okay. Are you aware, does the Rexburg City Police Department work with and coordinate with other law enforcement agencies in the area?
Yeah, we work with Fremont County, Madison County, Jefferson, Bonneville. We're on a critical incident task force, so we help our detectives go to those critical incident task force clear down to Pocatello at times, as well as helping on other cases when we're called upon.
Okay, thank you. The state has no further questions at this time.
All right, cross-examination, Mr. Pryor.
So how would I address you, officer? Would I address you as sheriff, or what would be your police
chief of police?
All right, I want to show due respect. Chief, with all of these agreements with the other counties, we're assuming, aren't we, that all 5 of your detectives will be testifying at the same time, right?
I don't know.
Right.
Yeah, I'm guessing they wouldn't all be testifying at the same time.
Okay.
When would they be called up? I don't know.
Okay, well, if one of them were called one day and then went back home, and the other one was called a different day and then went back home, and then another one was called on a third or fourth day and went back home, and a fifth one was called on a day and went back home, is it possible that you could get help from Bonneville, Jefferson, Madison County, Fremont County for each of those 1 days for an additional law enforcement officer to help you while the one officer is testifying, or even 2? That's possible, isn't it?
Well, it's not as easy as that. It's not like I can call in one of the other detectives to come in and handle one of my officers' cases that they're working on.
Well, it may not be working on the cases, but if there's necessity that there's some patrolling or other things to do, it's not going to impact a case if a detective is taking a few hours off from a case and has to take a day off and then work on the case the next day. You'd agree with that, right?
Yeah, if I was just missing one detective for a day.
So spacing them out or accommodating your schedule with your detectives so it doesn't have an impact, that's something that's a viable alternative, isn't it?
It would depend on how far they've got to travel.
Okay, all right. Now, I'm a little concerned. Obviously, you have detectives that are within your organization that are involved in this case, right?
That is correct.
And they obviously can't be concerned with providing security for Ms. Vallow. She's in the Rexburg. Is she in Madison County or is she under your supervision with Rexburg?
Neither her or Chad are under our supervision.
They're under Fremont, but they're housed in Madison. Well, not anymore, is she? So I guess my question is this. Well, Judge, I'll draw back on that. I'm gonna save that for a later day. I don't think I have any more questions, Judge. Thank you.
All right, any redirect, Mr. Wood?
Not at this time, Your Honor. No.
Okay, thanks, Chief Terman. That'll conclude your testimony then. Thank you for your appearance this afternoon.
Thank you, Your Honor.
You're welcome. You can log off of the call. Mr. Wood, do you have another witness to call?
No, the state has no other witnesses.
All right, does either side have any additional evidence or witnesses to call before we get to the argument section of this hearing? Mr. Pryor, starting with you.
Judge, I would just have argument.
All right, Mr. Wood.
No further witnesses.
Okay, we'll consider the evidence presented then. At this point, I will allow argument. It's your motion, Mr. Pryor. If you'd like to make argument, and then hear from Mr. Wood after that.
All right, Judge, I would start out, and we're cutting out a little bit, so my hope is that the court can hear me still. Okay, thank you. Judge, I would start out, but I want to cite the case of Irvin versus Dowd. And the case is 366 US 717. And it's a case that I think is directly on point as it relates to a change of venue. This is a rural community, and the case of Irvin versus Dowd talks about the inherent prejudice when you have a very small rural community. And I think in the Irvin versus Dowd case, they were talking about something that's probably 5 or 6 times bigger than St. Anthony. But in that particular case, Judge, they talked about the prejudice that's inherent when there is such media saturation to such an extent that everybody knows about the case, everybody knows about what's going on in the case, and that the very nature of that excessive and unrelenting publicity causes an inherent prejudice for a defendant to get a fair trial. And I would ask the court to take a look at the Irvin versus Dowd, because the Supreme Court of the United States has set forth criteria, and it's very specific criteria. It's very specific criteria that addresses under what circumstances does a barrage of publications and information cause this inherent prejudice. I would also like the court to look at it's Riddell versus Louisiana, 373 US 723. Again, it talks about how excessive press coverage causes and deprives a defendant of a fair trial. Now, my concern is this, is obviously in the small rural community of St. Anthony, we have had a tremendous amount of attention brought to this. That attention includes a number of pictures, obviously, on East Idaho News. Those pictures include a decoration of the county courthouse. Now, those decorations of the county courthouse in Fremont County, they came down after I made my bond reduction for Mr. Daybell well over a year ago. And it was only after I made that argument did that come down. Then the pictures on East Idaho News talked about the sign that was on the very front when you drive into St. Anthony. There's a sign in the very front of the city that you drive into, and on that sign, and for many, many months, Judge, and you'll look at the publications that were submitted to the court, Justice for J.J. and Tylee. Now, that is a constant reminder for anyone who drives into St. Anthony and sees the publicity that is being presented. Now, again, right after the Daybell bond reduction motion, strangely enough, excuse me, that sign came down. The signs and the advertising at the Madison County Courthouse, and there's pictures of that as well. The pictures in Madison County and the ribbons decorating Madison County also came down. My concern, Judge, is that there's been so much publicity, and you're talking about a rural community, and I think Irvin versus Dowd and Riddell versus Louisiana are pertinent and offer some insight in what the court should be looking at in terms of how you make a decision as to whether or not this publicity has reached that level. There's also a case, Judge, and it's United States versus Rewald, R-E-W-A-L-D, 889 Federal 2nd 836 from the Ninth Circuit. It's 1988. Again, that's something else that touches on the issue of what's appropriate in terms of a significant amount of attention. Judge, when I took on the obligation to represent Mr. Daybell in this particular matter, I had no idea that this was going to garner so much attention. I would suggest that, Judge, other than a case that occurred in Minneapolis, this case has drawn more media attention than any other case that I can think of in recent history. It has been incessant. The exhibits that have been admitted, 1 through 8 of my exhibits, they aren't just a couple of pictures, Judge. They are a significant number of videos. They are a significant number of stories. They are a significant number of posts. And it's overwhelming, the amount of attention this case has brought. Now, I'm not going to say what Mr. Wood's argument is, that maybe I haven't shown enough prejudice. Well, I think that if the court reviews Irvin versus Dowd and looks at the cases I cited, you'll see how the United States Supreme Court addresses this issue of incessant, excessive publicity and how it interferes with someone's right to a fair trial. I would submit to the court that the amount of attention has been overwhelming. Now, on August 4th, we had a preliminary hearing. It was the second day of the preliminary hearing. And on August 4th, Court TV and I believe East Idaho News published a letter, and I have included it in the submissions, from President Nelson of the Salt Lake City, obviously the president of the LDS Church. And that letter came out on the second day of the Daybell hearing. Now, I've submitted to the court, and I'm not going to go into the details of what was said in that letter, and I will leave it to the court. But what took place afterwards, Judge, were a number of conflicting opinions about people who felt the timing of that letter on August 4th was inappropriate by President Nelson. Now, I have had a wonderful opportunity, if there's any saving grace in me doing this, is that I have jumped into the task of learning as much as I can about the LDS faith. I've tried to teach myself. I've read many of their books. Chad actually provided me one of their books, and I read that. And I did some research on President Nelson. He has done nothing but live an exemplary life. He has been a pillar, and he's been an amazing role model for not only people in the LDS faith, but for people of all faiths. This is a man who has been absolutely exemplary in his conduct. Now, I think that and I'm not going to speak for him, but I think that his motive at that time was to say, listen, let the judicial system play out. The problem is that I don't necessarily agree with maybe his lawyers and the way they drafted that letter, and maybe he needs to look at some other lawyers. But this is not on President Nelson, and I will never disparage him, because everything I've learned about him and read about him is that this is an amazing human being.
Your Honor, I'm going to object on relevance at this point and facts not in evidence.
Okay.
Well, I'll consider the submission of the latter, but I think we're outside of the scope of this hearing.
Okay.
This line
So
of
I think that what President Nelson was trying to do was he was trying to downplay all the attention for Mr. Daybell in this case, but that submission on the second day of the preliminary hearing brought a lot of attention, and it came directly from the LDS Church, the top of the LDS Church. And again, I don't think President Nelson intended what he did was going to cause that problem, and in fact, I'm almost certain of it. But it did bring a lot of attention. Then sometime later, there was a submission. And this was at the request, and Judge, I've included it as part of the exhibits, and it's in the exhibits. If the court wants the date of when those exhibits were submitted, I believe that was on Fox 13 of August 12th of 2020. That should be in the documents that I provided to you. And what that was a letter from Heather Daybell. And I've included the entire letter as well as the media article that was attached to that. And in that particular letter, Ms. Daybell talked specifics, and she said some very unpleasant things about Mr. Daybell. But the concern I had was this, is that in the letter, she talks immediately, one of the first sentences was, at the request of President Dowling of the Henry Fork Stake. And this was also advertised on Court TV. Court TV ran with this story and publicized the entire letter and talked in detail about what was on what Ms. Daybell had said.
Your Honor, I don't want to interrupt Mr. Pryor, but if we are going to be going into these specifics, I'm going to ask that we do it in the breakout room. And he's entitled to argue. I'm just saying if we're going to argue those facts that we've tried to not broadcast, I think that should be done in a breakout.
Judge, and I'm not broadcasting anything. I'm speaking in general, and I'm trying to be as sensitive to everybody as I possibly can.
All right, Mr. Pryor, hold on. There's an objection. I need to make a ruling on that. I am going to sustain that objection in terms that I think it goes beyond the admonishment I've had in terms of the specifics of the exhibits. Those are in the record and will be considered by the court. And I think if you would just refer to those by reference, but without going into the detail in your argument, knowing that those will be considered by the court. So if you'd like to point out or highlight any specific exhibits and how you think those exhibits legally affect this issue, then make argument on that, Mr. Pryor, please.
And Judge, my concern is that's tying my hands in terms of arguing specific facts about these things. But I'll obviously accept the court's admonishment and I'll move forward. So in any event, I would ask the court to take a look at the documents and all of the exhibits that were submitted in regards to Ms. Daybell. I would like the court to take a look at the area that was impacted by Ms. Daybell's letter, and as well as read the article that talks about the scope and the range of where her letter reached and the number of people that it reached. Then we move on, Judge, to the next issue. Now, the next issue is that throughout this proceeding, there have been a number of vigils. Those copies of those articles are included in the documentation that I submitted to the court. There was a vigil, I believe, in Rexburg. There was a vigil that was done in Idaho Falls. My recollection is the one in Idaho Falls brought in several hundred people. I believe there was a vigil in St. Anthony, and there was a vigil in Boise. And the vigil in Boise drew, I believe, 24 people. So it wasn't as well received as the ones over here in Eastern Idaho. But the fact is that there's been the community brought together, and they've had these religious vigils, or however you want to characterize that, in talking about and bringing attention to this case. That obviously brings citizens from all over Eastern Idaho and it draws attention to the case. The next issue, Judge, is we are in a situation, and I'm going to move forward, where we are then having pictures of various businesses in the community selling items of memorabilia. Various citizens in the community, such as a bakery, that in their bakery at a very well-known grocery store in Rexburg are selling cupcakes that have messages that are directly tied to this particular case. And I'm going off, Judge, I apologize, but I'm going off of my slides. My concern is this, is that a combination of the significant amount of media attention, a combination of how the community has brought themselves together to conduct vigils, a combination of letters that have been sent, particularly in the Henry's Fork stake, that have had an impact. And we have no way of knowing when an email is sent out, what's the scope of where that email went to. The combination of people selling memorabilia such as sweatshirts and cupcakes in businesses within Eastern Idaho that directly reference this particular case. A combination of two courthouses in Fremont and Madison County, in which both of those courthouses have put up ribbons around the courthouse that have been posted by East Idaho News. A combination of the number of signs all over the community. Now that's going to have an impact, so I don't see how that's not prejudicial. And when the court looks at Irvin versus Dowd, you will see how the Supreme Court has ruled in that regard. Now, obviously, we're disappointed in the court's ruling as it relates to David Bryant and the survey that was done. But the reality is the results of that survey are disturbing. And the reality is that there has been an incessant amount of attention drawn to this case. And the reality is that what we need to do is get this out of an area where there is such a rural community that has made up their mind, that have, for all practical purposes, Judge, have got on the bandwagon of vigils, merchandising, and a variety of other things. And we need to move it to a place where there's a larger population base. And unfortunately, like many states, there's one large population base, and that's in Boise. And the likelihood is that if we are going to move the case, Boise would be the most obvious place to try to find jurors who either have not made up their mind or have not had a significant amount of attention drawn to this. To suggest that a rural county in eastern Idaho, we can get a fair jury when this thing has been incessantly on the news for almost every day is absolutely ludicrous. And to suggest we can go to Madison County, to suggest we can go to Bonneville County, and if the court decides to move venue and considers Bonneville County, at that point, I am going to ask the court to take another look at our survey and apply it as I don't think it's appropriate that anywhere in the 7th Judicial District this thing should be heard. My preference and choice of preferences are simply this, Judge. I would ask the court to consider Boise. I would ask the court to then, if the court did not consider Boise, I would ask for Twin Falls. If Twin Falls is not appropriate to the court, I would ask the court as a third choice to go to Pocatello. At that point, I think that we are far enough away. My final concern is this. I have no doubt that Sheriff Lem Humphreys is a honorable man, and I think he's a good man. I have only had one conversation. I don't even know if Sheriff Humphreys would remember that. We ran across each other on one of the streets in downtown St. Anthony, but I think he made a big mistake, and we all make mistakes. And I think in this instance, Sheriff Humphrey was honorable enough to say, I made a mistake. I posted this on my personal Facebook account, and I advertised that out there with not really thinking through the impact that would have. But the difficulty is when you're the sheriff in a position of authority in a rural community, and you post those things and talk about justice for JJ and Tylee, it cannot help but to have an impact on this community and influence them some way. So in conclusion, Judge, I would ask the court to strongly consider moving this case entirely out of the 7th Judicial District. I think that based on the cases that I presented, based on the 8 folders which contain subfolders of many, many, many documents of a variety of forms, it just doesn't make sense to keep it here. And the difficulty is this, is if the court even considers keeping it in the 7th Judicial District, at that point, David Bryant and his survey should be considered by the court, because at that point, we have a survey with legitimate results that says, unfortunately, 82 to 80% have already made up their mind that Mr. Daybell is guilty. This is
I'm not going to object to any comments on the subject of the polls. It's not in evidence.
Okay, and Judge, that's all I have. Thank you.
All right, and that last reference to the exhibit that was not admitted will not be considered by the court, so I won't consider that part of the argument as well. Thank you for the argument then, Mr. Pryor. Mr. Wood, state's argument.
Thank you, Your Honor. Before I get into the legal argument, just a couple of evidence issues. Mr. Pryor, in his documents that were submitted and admitted, in the metrics folder, there's 2 documents that we'd like to speak about. And I'm more than willing to do that in a breakout room. It's just data, so I don't know that it's objectionable in any way, but I'll leave that to the court's discretion on how we discuss it.
And Judge, I'm not opposed to Mr. Wood bringing up. I'm fully aware of the metrics and East Idaho News' readership as it relates to Boise and Idaho Falls, and I'm happy for Mr. Wood to go into that. I'll be responding though.
Okay, well, if you'd like to, you can, Mr. Wood. That particular exhibit, I don't believe carries any danger of further prejudice, so I think it's fine to review to those metrics or discuss those metrics here on the live stream, Mr. Wood. So if you have any specifics of that you'd like to discuss, go ahead.
So there's 2 documents. They're East Idaho News' user data hits on stories. There's 2 of them. They each have 25 cities. I would note that there's not a single city in Fremont County that shows up in the top 50 cities of hits on East Idaho News Stories. The number one city is Salt Lake City. The second city is Boise. But we're not actually here to talk about Boise or Salt Lake or anywhere else other than Fremont County today. And there's not a city in Fremont County that shows up there. I think that's important. So last
What I
week,
guess part of what we have to look at there too is the population base. I mean, last I checked, I think Fremont County's got about 12,000, around 12,000 people. And, you know, when I look at that list, I guess what I'm getting at is number of hits as a percentage of population. So if you've got a certain number of hits in Boise, but there's 500,000 people in Boise, then Fremont County at 12,000 may not show up. And of course, the concern is the amount as a percentage, I guess, of the citizens that may have been exposed. So I'm just pointing that
Sure.
out. I think a factor that must be considered.
and absolutely, I would point out that there's actually in the most recent census, there's more than 13,000 people. That's not a big difference than 12,000 people, but
Okay.
it is, you know, that's the data.
Yeah.
Now, I agree, Your Honor, and quite frankly, some of this data is a little bit murky, but it's still remarkable that in the location of trial, nowhere in Fremont County even shows up in the top 50. And that's all we're submitting that for. As the court noted in the status conference last week, there is a presumption that venue is proper in Fremont County, and that's where the trial should be held. And it's the defense's burden to overcome that presumption. There's two types of prejudice when you're talking about a fair jury in terms of venue. There's actual, which we can't talk about because you have to actually try to pick a jury to get there, or presumed. And at a minimum, the defendant's burden is that he has to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And in State versus Haddon, it's an Idaho case. The court there recognized that most cases of consequence garner at least some pretrial publicity. However, a presumption of prejudice requiring a change of venue attends only the extreme case. And there's a test for that. And that test remains whether the trial atmosphere has been utterly corrupted by press coverage. Further, State versus Yeager, it is not incumbent upon the trial judge to find jurors who are totally ignorant of the facts and issues involved in this case. Further, in Yeager, publicity by itself does not require a change of venue. An error cannot be predicated on the mere existence of pretrial publicity concerning a criminal case. Now, Mr. Pryor did predict my argument. Yes, the state concedes there's been a lot of pretrial publicity. The state would note that the state has made several attempts to lessen that. We asked that cameras not be allowed in the preliminary hearing, not to seal the hearing, and that's in another case, but it does bear on the publicity of this case. We asked that not be allowed, to simply lessen the amount. And we noted that there's no right to a camera in a courtroom. The Supreme Court's been explicit about that. Mr. Pryor and Mr. Daybell asked that it be shown publicly. So the biggest source of evidence involving this case, Mr. Pryor and Mr. Daybell asked that it be broadcasted to whoever may want to see it, whether that's in Fremont County or outside of the county. So the court has been very clear. There's factors that this court must consider in determining whether or not the defendant has met its burden. The first, the existence of affidavits or indicia of prejudice in the community. Mr. Pryor has not provided one witness to state that they've been prejudiced. He's not provided one affidavit. The case law is replete and talks constantly about providing affidavits to show prejudice. Not one affidavit has been provided. Not one indicia of prejudice has been provided. Not a single witness. The accuracy of the pretrial publicity. Mr. Pryor has not made any attempts whatsoever to show any evidence that the pretrial publicity was inaccurate. He hasn't put on any witnesses to talk about it. He hasn't indicated it himself. There's no showing has been made. The extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence. Again, the defendant is on the burden to show that the general public has been exposed to inflammatory publicity, inaccurate publicity, or publicity based on non-admissible evidence. No such showing has been made. I'll just briefly reference the Heather Daybell email, and I'm not going to get into the facts of it. He can't show how many people received it. He can't show how many people read it. He hasn't produced a single affidavit from anyone saying they were prejudiced by it, nor has he produced a single affidavit of any individual saying they're prejudiced by any of the news. The one area where the number of articles, the state does concede there has been an extreme amount of news surrounding this story. However, the court is clear. That alone does not create a presumption of prejudice.
Mr. Wood, though, on the factors the court does consider, I think, though, the amount in and of itself is certainly a factor, I think, that gets considered. I would note there's a case, State versus Hall, which is an Idaho case, 111-827. And that says impartiality may be affected adversely by the quality or the quantity of pretrial media coverage, and goes on to state that when prospective jurors are incessantly exposed to news stories selectively packaged for mass consumption, they may become subtly conditioned to accept a certain version of facts at trial. Such repetitive exposure may diminish the juror's ability to separate information absorbed before trial from information presented during trial. And that cites to another case, State versus Brooks, 103, Idaho, 892. So while there's an argument maybe that the publicity has been accurate, I think just at some point in overwhelming quantity may be something that could lead to that issue discussed in Hall. So I haven't reviewed through all of the exhibits yet to see where we are on that, but I want to let you know that's a concern I do have, is just strictly based on quantity of coverage based on that case.
Well, and it's absolutely within the court's discretion to do so. Like I said, that is one of the factors, is the number of articles. I would just point out, though, that the case law is clear that press coverage itself does not create a presumption of prejudice, but the court is absolutely correct in its discretion to review the number of articles and the substance of them. And that dovetails with whether the potential jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. And I think there's been no showing today, and obviously the court has those items in evidence. It can review those items, and it can make for itself a determination whether or not it's inflammatory, whether or not it's accusatory. I don't know that I've seen a single East Idaho news story that said anyone was guilty or anyone's not entitled to a fair trial. That would be inflammatory. Anyway, I think the court is entitled to absolutely look at that and make that determination. But the facts that have been related are relevant, that the state has seen, and I'll let the court make its own determination, but appear to be true. They're not fortunate facts. They're not good facts. They're not fun. They're disturbing. But accurate representation in the media, absent of showing the prejudice, it should not be enough. And then finally, the length of time elapsed between the pretrial publicity and the trial, and any assurances given by potential jurors themselves concerning their impartiality. This is a little more difficult to look at because we don't have a trial date set. We don't know when trial is going to be, nor do we know what news is going to come in between now and the trial. We don't know if another case is going to come along and blow this one out of the water. We don't know if this case will become the biggest case in the country. So that's difficult for a court to make a determination on that. Again, Your Honor, there is a burden of proof. The defendant is responsible to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And for that presumption of prejudice, He has to show that this is an extreme case, whether the trial atmosphere has been utterly corrupted by press coverage. I think to get to that point, Your Honor, he has to show some actual prejudice. He has to show, he has to have some witnesses. He has to have some affidavits of people who show prejudice. And he can smile and shake his head no, but that is the burden set out by the case law. And the state will, again, the one thing I do want to point out, there's a lot of talk about the press coverage. There's been nothing that links it just simply to only in Fremont County. It's all over the state. And so I think that's important for the court to consider as well. The hearing today is about Fremont County, and as far as Fremont County is concerned, I don't believe that burden has been met.
All right, thanks for the argument, Mr. Wood. Mr. Pryor, I'll allow you a rebuttal argument if you'd like. Before I do want to address that fact of what's the direct evidence I have about any prejudice within Fremont County itself that's been presented today or that's in the record. And the other issue is, well, not just on that, but why, what would be I know there are some downsides, but why would it not be appropriate to potentially go see if we can get a jury picked? And if that, through the process of voir dire, obviously we can vet out jurors and see where we land. And then if we determine through, instead of the court having to make a determination here based on this, seeing what actually happens when we get enough jurors there to call, why wouldn't we make a try there first before we go through all of what's going to take to move the trial? So those are the two issues I'm thinking about in this decision, if you want to address those.
And Judge, I'll address your first decision about trying to get a jury in Fremont County and then seeing if we're able to do that. The concern, Judge, is in many cases, that's not an unreasonable request. But this isn't any case. This is probably the biggest case in our country right now. And the case involves 6 counts that could cause Mr. Daybell to be given a lethal injection. And what the court is suggesting is that we're going to pick a jury. And oh, by the way, if we're not able to pick a jury out of Fremont County, at that point, then maybe we need to look somewhere else. But the picking of a jury is not just as simple as bringing 100 people in and saying, let's pick 100 people and see if we can find some people to do this. There are going to be, and then obviously the court's going to see these motions, but there are going to be studies. There's going to be questionnaires. There's going to be a lot of effort. And in my past, when I've been involved in significant cases, there have been times when picking a jury has taken a week, has taken 2 weeks. And if the court is going to invest a week or 2 weeks in picking a jury, and then we come to the conclusion that we're not able to pick a jury here, at that point, we then have to find a place to find a jury to pick and go through the 2-week process again. It would seem that's a waste of resources. Mr. Wood seems so concerned about resources that he forgets that this is Mr. Daybell's right to a fair, impartial jury. And even though he's waived a speedy trial, Judge, Mr. Daybell's been locked up for a significant amount of time. If for some reason in several months from now, we're not able to come up with a jury, it's going to be several more months, maybe even longer, before we can get into another jurisdiction where we're going to pick a jury. So the reality of it is this, is that taking a test run and taking a stab to see if we can do it. When you're dealing with a death penalty case, that's not the manner in which you proceed. The manner in which you proceed is you find an appropriate jurisdiction that you know you have the best chance to obtain a fair and impartial jury. And from my position, the largest metropolitan area in the state of Idaho is Boise, the Treasure Valley. Whether that's Ada County, whether that's Canyon County, that's where we are more than likely to find the largest number of people who may not have heard about this or have may not made up their decision. Now, the prejudice and the direct prejudice question, Judge. This court made it very clear, and I advised the court that I had a slideshow that I was intending to show a number of slides, and I was intending on putting on a significant presentation. This court was not going to allow me to present certain slides and certain evidence. In fact, the court stopped me on the Heather Daybell thing and said, I'm not letting you get into this. Now, isn't that the very definition of inflammatory or influencing? when
Well,
you,
and to be clear, I'll review that evidence. The evidence is there and you can refer to it and I can look at it for what it is and make that determination. So it was only in expressly relating to it an argument that I curtailed there, Mr. Pryor.
right. And you know, and Judge, if it wasn't so inflammatory, if it wasn't so concerning, we'd be showing it to all the people watching right now. But the reality is there is disconcerting stuff. And Mr. Wood can put in his pleadings, and Mr. Wood, and this is all on the stuff that I submitted, Mr. Wood can do a press conference and announce that he's seeking the death penalty, and Ms. Blake can get on there and speak.
No, Jack, that's a fact, not an evidence, and that never happened.
Well, that's the objection sustained because that's outside of the scope of anything presented at the hearing here, Mr. Pryor.
Well, it's in the evidence, Judge, and it's in the videotapes that have been submitted. So
Okay, it's there, then I'll consider it, but
and at that point, Judge, you know what? Mr. Pryor hasn't got on public TV. Mr. Pryor hasn't gone on court TV. Mr. Pryor hasn't gone on Dateline or anything else and done anything like that. But what has happened in Fremont County is Heather Daybell wrote a letter to the Henry's Fork Steak. That letter was disseminated, and the court can read the article about how far it was disseminated. That's a problem for us. That's a problem for a fair trial. And then what did we hear about today? The sheriff of Fremont County in 2020 on his personal Facebook account posted images of the Daybell case. Now, Mr. Wood brought up, well, you didn't mention Chad or Lori. No, he just mentioned Tylee and J.J. on it, and then talked about some other things that were posted as part of this. If you're telling me that a sheriff in a county whose job is part to investigate this case and to provide assistance to Mr. Wood gets on his personal Facebook account and advertises out there, you're telling me that that's not going to have an impact? You're telling me that's not going to influence citizens in rural Fremont County? That is absolutely ridiculous to suggest that it wouldn't influence people. Finally, Judge, again, I keep going back to this. Mr. Wood is misconstruing the case law as it relates to venue. Mr. Wood is absolutely misconstruing the case law and what it says. If the media coverage is so great that it inherently is going to influence the outcome or attention brought to this case, that's in case law, that's addressed in the Hall case that the court brought up, but more importantly, Judge, it's addressed in our highest court in the United States, the U.S. Supreme Court. And they have clearly set forth the standards, not the standards Mr. Wood would like you to follow, but the standards that all of us should be following. Judge, I've been doing this for a little north of 25 years. I have never seen a case that has brought on so much attention. I have never seen a case, and the court can go back, and I can't even imagine the task this court has of having to go through all of the evidence that I've submitted. Many, many items of evidence that this court's going to have to sift through, and it's a huge task. It's a monstrous task. It was a monstrous task to go through all of the stuff for me. I can't even imagine. But Judge, if it's that big of a task, that would suggest that the media attention has been significant, more than significant. It's been outrageous. And it's not a coincidence that in Idaho Falls, Idaho, now I don't want to misstate how far St. Anthony is from Idaho Falls, but these folks in this side of the state have their very own news agency, East Idaho News. This is a very prominent news organization. And whether I agree or disagree with everything that they put on there, and obviously I'm not going to make a public statement, but I don't agree with what's been said about Mr. Daybell. In fact, most of it I disagree with. Almost all of it I disagree with. And unfortunately now I've broadcast that. But that's not the meter that you go by. You apply the Irvin versus Dowd in the cases I applied. And there is no way that with the amount of tension that Mr. Daybell could get a fair trial here. And the difficulty is, it's not let's like shoot basketball hoops and hope maybe we could sink a few and get a fair jury. We don't get to take a try and say, well, let's take a stab at it. And if it doesn't work, well, we'll move it somewhere else and take another stab. That just doesn't make sense. So I would encourage the court to please, this needs to be in the western part of the state in Boise, Idaho, in Ada County, and that would be the best chance we could get for having a fair and impartial jury.
Okay, Thanks for the argument, counsel.
Your Honor,
To a
I
little
don't want to
more-
re-argue anything.
I was going to say,
If I'm
Mr. Wood, if you have
interjecting-
any additional argument, you may.
All I wanted to say, Your Honor, the state just really, the way that Mr. Pryor has discussed Sheriff Humphreys, we strongly disagree with. He hasn't cited any law, any rules of ethics, or anything else that he's done wrong. And the way that he treated him as a witness and the way he spoke, we just strongly disagree with, and we'll leave it at that.
And Judge, if he's going to make a statement, then I want a response. Sheriff Humphreys acknowledged.
No, Mr. Pryor, listen, he testified. I gathered the reason for the testimony. He made his answers. I'll take that under advisement. I don't need further argument to construe what he said or what he did. So I'll consider the matter submitted in terms of both argument and evidence. So the court needs to review through the evidence, obviously, that's submitted today. I'll issue a written decision on the motion to change venue, which again, to be very clear, does not actually change venue of the case. It's a transfer of trial under Criminal Rule 21 and also under Title 19, Chapter 18 of the Idaho Code. So I will take it under advisement, get a written decision and determination on that, and that will conclude the hearing. Counsel, while that does conclude the hearing, there's one other matter I wanted to take up separately as it relates to a motion that's been sealed. And while I have counsel on the line, I just want to briefly address that. So we will conclude this hearing on the motion. And then if we could just briefly go into a breakout room for a moment with Mr. Pryor and the prosecution and the court reporter, I'll address the issue related to that other motion, and then we'll be in recess for the day on the case. So Madam Clerk, if you'd set that breakout room up, then we will talk further there.
Okay, you guys, so that's it. We are going to await now. I will have to keep an eye on the record. I'm sure Vine will notify me when the judge is going to come back with his decision. It's probably going to be a week or so before he comes back with that, or even possibly maybe tomorrow. We will be live again tomorrow. There's still, I still have the court thing up on the other side, and Mr. Wood just had a meltdown because he can't get into the breakout room. I'm just watching here for a minute, you guys. Oh, they're gone. Okay, they're all gone now. Wood was having a little bit of a meltdown and banging on something because he couldn't get into the breakout room. But anyway, I don't know at this point what the judge is going to decide. I think he's going to, my guesstimate is going to be that he's going to try and have this in Fremont County. They're going to try, I think, to get a jury, and if they can't, then he will make a decision on whether it's got to be moved or not. But I do think that he's going to try and have this kept in the county. We'll have to wait and see what the judge decides. We're going to be here again tomorrow morning, 10:45 a.m. Eastern. They still have to go over the motion to sever. That will be obviously tomorrow morning. So I'm going to get that all set up. Watch for that first thing in the morning so you can click on the reminder bell so you'll be reminded when that starts. But I will be going live again at about 10:45 a.m. tomorrow morning. So yeah, no matter where this ends up, the evidence is the evidence. The truth is going to be the truth. And what's going to happen is what's going to happen no matter where it's held. But we can't think that far ahead right now. We got to get through all these motions that seem to be endless and just get to a secure date for this trial to start and see where we go from there. I think it's going to be a long, dragged out trial. I think it's going to be filled with gory details and such that a lot of us, I think I will be covering it if they do stream it. But I think a lot of this, I'm going to have to just let it stream and walk away from my computer. Some of the stuff I've already read has been more than enough for me to be able to try and handle. But let's see what happens tomorrow, you guys. They're going to try and have Chad's trial severed from Lori's. That's going to be another fight for tomorrow. Let's see what happens there. And possibly, maybe even tomorrow, the judge may make a decision on the change of venue. We don't know. But I will see all you guys again tomorrow morning, 10:45 a.m. Eastern. I want to thank each and every one of you for being here, for taking the time out of your day to follow along with us here. And thank you to my mods. Without you guys, I'd have one heck of a time here. I got the best mods ever, and I thank you guys from the bottom of my heart. I thank each and every one of my subscribers, and even those who aren't subscribed, please, think about hitting that subscribe button. I take a lot of my time to do this for you guys, and it's a small thing to ask for you just to hit that like and subscribe button. Okay, so until tomorrow, you guys, please take care of yourself. Please stay safe. Love you to the moon and back, and I will see you again tomorrow morning. Bye-bye for now.